Okay. Sorry, I'm a little get myself together. It started like when the judge said it would start yesterday. I was hearing mixed things.
Can you get Zoom set up while I'm getting started here?
So let me get you guys up here.
You do it on this computer, and I'll just join the meeting on this one.
Make sure we're live here. We're live. We're good. Okay. Let me switch the screen. What's up, everybody? Welcome. So oh shoot, everything's kind of mixed up. I was messing with the screens yesterday, trying to fix the settings. 1 second. There we go. Got double audio. Okay, fixed. Oh, welcome. Hopefully people get the memo that we started it. It was set for 12, then we pushed it back to 1 because it didn't seem like it was going to start, but then they did start. Thank you, Mandy, for letting me know that they were starting. So we're here. And by the way, we're on the backup channel too. Make sure you check out the backup channel. Thank you for people that took the time to subscribe over there. I really appreciate that. We got monetized last night. They approved it. We were on there this morning, talk about the Hamas attacks, Israel, Palestine, all this crazy stuff going around the world. For the people that were there watching with me this morning, I was just watching the Democrats doing the House of Democrats doing a news conference. And there was contention about whether babies were beheaded or not. And so there was some sort of fact check thing saying that the 40 babies were murdered, but that they weren't beheaded. The fact check. But now, I don't know, the House of Democrats are saying that babies were beheaded. I don't know. So a bunch of whole mess going on. So just make sure you check out my backup channel because I'm going to try to follow that story. Probably later on today, we'll jump on again and catch up on some of the updates of the insanity going on. Oh, and the other thing too, on the backup channel, I posted another highlight. I'm going to be posting a few trial highlights. So if you're one of the people that have been looking for some of the videos, it's on iCkEdMeL clips. Okay, just type in iCkEdMeL clips, or you can just go to my main page. It's there as well. Wherever you want to go, it's there. And when you go to the page, iCkEdMeL clips, you just boop. All right, right on the front page, there's trial highlights, or if you just want to watch the trials on my main page, though. The actual trial videos are on my main page. So just trial highlights. You can see the highlights. I'm updating it. I put the opening statement. I'm going to put the testimonies from the sibling and Ronan. And the last thing I plan to do is to put both of the doctors together. You know, like the prosecution doctor versus the defense doctor, so people can watch it back to back. All right. Okay, so we're here. We'll give time for people to join. I was about to go take a nap. I'm glad I didn't.
All right, now that we've got the technical stuff out of the way, we are back in session on State versus Ferriter. Let me have appearances, please. Okay, all sides ready to continue with the discussion that we started yesterday afternoon regarding the jury instructions?
Yes, Your Honor. So I have made a final copy of the affirmative defense. It seems like we are on the same page. Everything. I took out the burden of proof for the defense. I kept it for the state.
So here's the question I have after, and I read this very carefully and looked at it probably more than I should. But I came away after reading Radford with the feeling that in this particular case where I've limited, based on the motion for JOA by the defense, to just that prong in the information that dealt with the confinement and the caging, that did not involve bodily injury and did not involve corporal punishment, I came away with the feeling that the defense does not apply with what's left of count 1, but it would apply to the lesser. And in looking at the draft of the instructions, it seems to me the defense is included both as to the charge of aggravated assault and to the lesser. But my reading of the law is that it doesn't apply now to count 1 as it currently stands with how I've narrowed it. So let me hear both sides weigh in on that. And I apologize if I'm raising an issue that both of you hadn't looked at, but that's something that jumped out at me as I looked at this.
That did occur. Yes, that I agree, Your Honor. That did occur to the state because there's no
corporal punishment that's involved in count 1 anymore.
right. It's not corporal punishment. It's not reasonable punishment, and it's also not physical punishment. However, jury instructions are sometimes a way in which a case can be reversed. And so,
Well, if the state is telling me that you don't want to take a chance and you want it to be included, I won't get in the way of that. But I'm telling you, sitting up here on the bench and looking at the case law, in light of how I've narrowed the case on the count one, I don't think the affirmative defense of corporal punishment, permissible corporal punishment, applies to count one. It clearly applies to the lesser. That's not even an issue for me. And I will say that you've drafted, even in count one, you've drafted the instruction the way I would have ordered it this morning, putting the burden of persuasion on the state. In light of everything I looked at, that would be where I would place the burden under the case law. There's no perfect guidance on that, but that's kind of, I'm doing the same thing that you're doing, being cautious and putting the burden on the state so that if there's any error, it's something that shouldn't be harmful to the defendant.
right. So we put it in because the defense was requesting it. Let me think about if we want to remove it for a second. I certainly was going to argue that it doesn't apply as charged, but we'll see what the defense has to say first.
All right, so let me hear from you, Mr. Waheed. You moved successfully for JOA on a portion of count one, which knocked out the great bodily harm aspect of that, and which in the court's view left me with, as far as count one goes, with that prong that I read when we were discussing the issue that dealt with the confinement and the caging that did not involve physical punishment. So by you being successful in that portion of your motion for JOA, what's your position now in terms of what I've stated, that I don't think that the affirmative defense applies as presently stands with the count one for aggravated battery or aggravated child abuse? I'm sorry.
Sure. Obviously, my position is it does apply.
But let me ask you, tell me, because if count, you agree that the aggravated child abuse count now does not involve any corporal punishment aspect, right? And the affirmative defense relates to permissible corporal punishment, doesn't it?
No, it's physical discipline, Judge. The actual wording is, it is not a crime for a parent or a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from the discipline.
All right, so your position is that the caging is the physical discipline.
Correct.
That it doesn't have to be corporal. I'm not sure I agree with that, but I understand your position. So if that's your position, I can see where you would argue that it comes and applies to count one as well, even with the way that I've narrowed it.
Yes, correct. And the instruction as it goes on is, it doesn't say anything about corporal punishment, to be clear. It does say physical discipline, and it's talking about
Debbie, I got it.
whether or not it was reasonable. I think that is exactly.
Thank you so much for the cash up, Debbie.
That is
Appreciate
exactly
that.
the
Took me a bit to get in
situation
there.
we're in right now. So
Gracias.
I do think it applies. Every case I've read, I'm not sure where the court felt it didn't apply.
The what didn't apply?
That this affirmative defense would not apply in this case.
No, I feel that it doesn't apply to count one for aggravated child abuse, but that it would apply for any lesser of that. And let me tell you why I get to that, and you can deal with it specifically. Because when I looked at the Radford decision, the Supreme Court of Florida makes the statement as follows: we agree with the 4th and 2nd districts that under the current statutory scheme, there is no parental privilege barring prosecution for felony child abuse under Section 827.03. Then they go on and say, indeed, Section 827.031, defining felony child abuse, makes no exceptions for parents or the equivalent. And then they say this, and this is what leads me to my conclusion about if the count doesn't involve corporal punishment as it presently stands, then maybe the affirmative defense doesn't apply. And this is what the Supreme Court said. Thus, it is not that felony child abuse by a parent is a non-existent crime, but rather a parent may assert as an affirmative defense his or her parental right to administer reasonable and non-excessive corporal punishment. So the Supreme Court spoke to corporal punishment, and I believe that caging doesn't, at least I wouldn't define it off the top of my head, as being corporal punishment. Corporal punishment in my mind is physical touching, and as the cases talk about a permissible battery upon a child subject to the reasonableness limitation. So let me have you address that, because that's what led me to the conclusion and why I raised the issue right up front as to whether it applies at all to the top level charge.
Yes. So that case, Radford, is before the amended jury instruction. So this jury instruction is actually later in time approved by the Supreme Court. And the jury instruction sits under 16.1 and under 16.3. It does not caveat in any way using the word corporal punishment anywhere. And it doesn't say, it doesn't apply to any of either A, B, C, or D under aggravated child abuse. So A and D are gone, I believe. We're left with B, C. With
spell that out for me. A
was the the A was the aggravated battery that the court found didn't apply.
Great bodily harm involving great bodily
harm. And then whatever the last letter was is the one where it talks about specifically intended child abuse, intentional child abuse. So those
which encompasses, by definition, great bodily harm.
It does.
Yeah.
So those two are gone. But what is left, which was torture, malicious, and unlawful caging, there is nowhere in the instruction that it carves out any exception for the parental affirmative defense for any of those subparts.
Well, okay, so the Radford decision, let me find out. I thought that was dealt in the Radford decision, and what I thought that it said is that any exceptions must be in the statute itself. Let me see if I can find that for a moment.
What's up, everybody? Welcome.
Okay, so
no notifications?
They adopt the language, I think, of the previous decision in Radford, where they were citing
no notifications. Wow. Ew, what happened?
I made a note of that, so I can't find it right off. Let me just bear with me just for another second.
You got a notification? You got notified? Some people got notified? Okay.
Okay, so the only other thing I would cite in the Radford decision is the Supreme Court's admonition toward the end, where it says, however, we conclude that this difficult task is principally a legislative function better left to the legislature. As the 4th District has previously observed, cases like this should stand as a warning to those, parents and others alike, who quickly turn to corporal punishment as a solution to child discipline problems. It is apparent that there is a serious risk of going too far every time physical punishment is administered. So that brings me back to where I think I started with this, is that because the corporal punishment is no longer a part of what the jury will hear on the aggravated battery, my conclusion still is that it's not a defense as the count currently stands. But that being said, I understand the state's position, and if the state is telling me that you don't want to take a risk that I'm wrong on this issue and that you would rather the parental affirmative defense be presented to the jury, I'm fine with that. At some point, there's going to be a judge who says that, no, I'm going to stick to my guns, and this is going to the way it's going to be, and it'll get tested on appeal again. But I'm not of that ilk at this stage, because the law, to be candid, is not crystal clear on which direction to go here.
Yes, that's correct. We agree with Your Honor, but out of abundance of caution, we're just going to leave it in there.
All right, so that takes away the issue for you, right, Mr. Waheed? So there's no issue then.
But we're still going to argue that it was not reasonable.
I understand, right? And the permissible limits are an issue with not only the aggravated child abuse count, but it will be an argument with respect to the lesser as well. Okay, so that was what I wanted to let you know that I had gleaned from my review of the decision and the instruction yesterday. I've looked at the instructions that were presented and everything looks fine to me. Are there any issues that I need to address with respect to the currently presented draft of the instructions?
The only thing was I didn't know if defense wanted 3.9B, the defendant's statement. The only statements that we have from the defendant are the ones from the video. I don't think that it applies in this case, but I just left it in for them to let me know whether or not.
3.9B.
Yes.
So what's your position on that? Well,
I don't think it applies, actually. I think that's when there's a statement usually to.
right, usually a statement made to an officer or something like that, or body cam. So 3.9B will come out. So just remove that from, and before we finalize this, we'll go back through each and every one to make sure we have the proper order. So 3.9 comes out. Any others that should be excluded, and then I'll go through the order in which I'll read the instructions to the jury once we reconvene.
That was it, Your Honor.
Okay, so let me go through the instructions. I'd like everyone to follow with me in the order that I'm going to read these. The jury will be provided with a copy of the instructions in the box, and they will be permitted to take the copy that we give them back to the jury room for deliberations. The only thing they will not be able to take back with them as part of the package is the verdict form. We only ever allow one verdict form to go back to the jury room. Okay, so the preliminary instructions, I will not read them again, but they will be part of the packet. 2.1. The same for 2.1A, note taking, I will not read that again, but it will be part of the packet. And then introduction to final instructions is where I'll start with the.
For the jury's copy, I did start at 3.1.
That's fine. Yeah, that's fine. So the 2.1 and 2.1A do not have to be a part or part of the jury copy package. Okay, so we'll start at 3.1 as far as what I'll read. Then 3.2. So as we go through each one, let me hear yay or nay from both sides so I have on the record both sides consent. All right, 3.1 everybody's good with, correct?
Yes.
All right, 3.2, statement of the charge. Everybody's good with that one, right?
Yes.
Yes.
All right. Then we'll go into 16.1, which is the aggravated child abuse instruction. And I will just note for the record that this instruction, in my view, is drafted in the vein that it puts the burden on the state to prove against the affirmative defense beyond reasonable doubt.
And Your Honor, I don't know if your copy had the mental injury, but I had spoken to defense. I took the mental injury out of it.
I think that does need to come out because that's not part of what's left. So
Yes.
you're in agreement with that?
I'm in agreement with that.
All right, so the mental injury paragraph comes out. So after the maliciously paragraph, we will then move to the paragraph, it is not a crime. So that will, and then I'll ask that you print me one final set of the changes. Okay. All right, and then we'll go to 9.2, false imprisonment. Everybody good with that?
Yes.
All right. And then 16.6, neglect of a child. Everybody good with that?
Yes.
Yes.
All right, so that will then mean we move on to 3.4, where we talk about any lessers. And so the 3.4 instruction will advise the jury that the lesser for aggravated child abuse is child abuse. Everybody good with that?
Yes.
All right. Defense, good?
Yes, Judge.
Okay. All right, and then that'll take us to reading the lesser.
So he could get just child abuse, I guess, versus aggravated child
In
abuse.
16.3 for child abuse, and that includes the same burden on the state to disprove the affirmative defense beyond and to the exclusion of a reasonable doubt. And mental injury remains in this one?
Yes.
Okay, all right, good enough. All right, 16.3 is good. All right, 3.5A, principles, everybody good with that?
Yes.
Yes, Judge.
Okay. And then we move into the standard, the 3.7, plea of not guilty, reasonable doubt, and burden of proof. Everybody fine with that, I presume, correct?
Yes.
Yes.
All right. And then weighing the evidence. The only issue I ever have with this is, do we need all of paragraphs 1 through 7? Have you, you've already pared this down somewhat, right?
Yes, Your Honor.
All right. Are you good with 3.9, Ms. Waheed?
Yes, Judge.
All right. And state is good with this since you presented it. Okay. That takes us to 3.9A, defendant not testifying. Is that going to be the decision that's ultimately going to be made? I'll do the colloquy. All right. So when I get to that, so that means that we'll be reading 3.9A and to the jury. After that, we go to instruction 3.10, rules for deliberation. I assume everybody's fine with that. That's standard.
Yes.
Yes.
All right. And then 3.11, cautionary instructions. Again, standard. I assume everybody consents to that.
Yes.
Yes.
All right. And then finally, 3.12, the standard instruction on the verdict. Everybody fine with that, correct?
Yes.
Yes.
All right. And then that takes us to the verdict form. I've looked at the verdict form. I don't see any issue that jumped out at me, so I assume everybody is fine with the verdict form, correct?
So, Judge, the only thing with the verdict form is I do think that there should be, underneath aggravated child abuse, we should have a slot for whether they find it's torturous or
Let me tweet out the stream since
Why would that special finding need to be made? Is it for any purpose on sentencing or any other aspect? Because normally I would not do it unless there is a specific need for a specific finding that drives the sentencing decision to be made by the court.
Well, we believe it goes to the unanimity issue, right? Which is that they unanimously found that, for example, that it was child abuse due to unlawful occasion, where they might not be in agreement on that. They might not agree that it's unlawful.
What case do you have to rely on that unanimity is required as to the reason for the finding of guilty on any particular charge?
It's not so much a case, Judge, as it goes to the idea of the jury coming to a unanimous decision.
But isn't the prevailing case law that if there are alternative means for finding guilt on a particular count, that is case law as I understand it, is that there doesn't have to be a unanimous agreement on the specific avenues of which you get to an adjudication of guilt, or excuse me, a finding of guilt, but that there has to be unanimity on the finding of guilt at the top level, that there doesn't have to be unanimity on the way you get to that. Do you agree or disagree with that?
I've definitely seen such cases like that.
Yeah. All right. So I'm going to deny the request to have any breakdown of additional findings. Well, I assume the state would be opposing that. I'm making I just don't think it's supported by the case law. So, any other issues with respect to the finding or the form of the verdict form? Mr. Waheed? No. All right. So then I'll go over the verdict form in detail. And then lastly, and I typically, in my court, the not guilty is the last one. I have them address the level of guilt based on the highest charge going down to a finding of not guilty.
oh, let's do that. Yeah.
And I can assure you that has never been a problem in my courts with juries reaching a finding of not guilty if they think a defendant's not guilty.
I know.
It happens.
It's so annoying when the attorneys don't turn on their mics.
I think I'm fine with the order of the presentation of the consideration of the issues for the jury. Then it takes us to 3.12A, single defendant. That's a standard. I'm assuming no one has any issue with that. All right.
No.
And then lastly, 2.4, evidence of other crimes, wrongs, or acts. I assume this is something the defendant probably requested, right?
No. Yes.
Yeah.
Yeah, it has to be read in the final instruction. Your Honor.
All right. All right. Okay. So that's fine. And then we'll go into 2.7. And after that point, we'll 2.7 is fine for both sides. Again, it's a standard.
Yes.
All right. And then we'll move into closing arguments. And then once the closing arguments are completed, I'll then read the final instruction of 3.13, submitting the case to the jury. Yes. All right. So that's the order of them. If you can print me out a final reading set.
Folks said that in Florida, so with no aggravating factors, child abuse and child neglect is third-degree felonies with a max of 5 years and a $5,000 fine. There's a poll in the chat. If you're not looking, there's a poll in the chat, and it asked how much time will Tim do if found guilty: 5 years, 10 years, 15 years, or 20 or more years. I'm going with 5 years.
The jury instructions. I think now would be appropriate to address the issue of the defendant testifying or not, and the court doing the necessary colloquy on that. All right. So, Ms. Murad, I know we talked about it already in the context of the jury instructions. This is a more formal addressing of that issue. Has your client made a decision in this case as to whether he will testify in his own behalf or not?
He has made a decision, Your Honor.
And what is that decision?
He will not be testifying.
Okay, so let's hand the mic to Mr. Ferriter. Mr. Ferriter, if you could start off by, you can be seated if you like, sir. Go ahead and raise your right hand.
Oh, you got
You
back
swear
up.
to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, you can put your hand down, sir. Go ahead and state your name and date of birth, please.
Tim Ferriter, 41775.
All right, and you read, write, and understand English, sir?
I do.
And what's your highest level of education?
College degree.
All right, are you under the influence of any drugs, alcohol, or other medications this morning?
I am not.
Have you ever been treated for any mental or emotional condition?
I have not.
All right, and just to give you the context of why I'm conducting this colloquy, as you've heard, your attorneys advised me that you've made a decision whether to testify or not. And so, as I mentioned yesterday, I need to make sure that that decision is being made by you knowingly and intelligently, freely and voluntarily. So that's where these questions are intended to go to put me in a position where I can make a factual finding on those items. You understand all that, sir?
I do.
All right, and you're represented by your attorneys, Ms. Murad and Mr. Wahid, in this matter?
Yes, sir.
And are you satisfied with their services?
I am.
All right, and have they done everything that you've asked them to do regarding the presentation of your trial and consideration of whether for you to testify on your own behalf or not?
They have.
All right, and have you had a full opportunity to discuss with your attorneys the pros and the cons and the risk and the consequences of testifying versus not testifying in this matter?
I have.
All right. And have they fully advised you of all those risks and consequences as far as you're aware of?
They have.
And have they been able to answer all of your questions regarding the various pros and cons, risk and consequences of testifying or not?
They have.
All right. Has anybody, including your attorneys, made any promises, threats, or tried to force you into a decision this morning that would be against your will?
No.
All right. So the reason I ask that is, and you've heard some of this from me before, there are basically three things that a defendant absolutely controls in a criminal proceeding. And what I mean by that is, although you can receive the advice and counsel of your attorneys, ultimately, I don't look to your attorneys to tell me what the decision is. I look to you to tell me what your decision is, because your decision is what governs. Those three things are: one, whether to plead guilty or not guilty; two, whether to go to trial or not go to trial; and three, whether once you are in trial, whether to testify in your own behalf or not. Obviously, you've already made and gone past two of those decision points, continuing with your plea of not guilty and also continuing with the decision to have a trial. So now we're at that precipice where I told you we would arrive at one day, once the trial were to begin, as to whether you should make a decision to testify on your own behalf or not. There are certain consequences that I do want you to be aware of if you were to testify on your own behalf. And one of those is that you will be subject to cross-examination by the defense. The only way the defense ever can have an opportunity to cross-examine you in this case is if you take that stand there and you subject yourself to direct examination by your attorneys. Then that opens you up to cross-examination by the state. You understand that?
I do.
All right. Another area is that do you have any felony convictions or misdemeanor convictions involving truth or dishonesty? They could also bring that out. Now, does the state have anything like that it would potentially bring out against Mr. Ferriter if he were to testify? All right, so that's not a real worry. It's a worry for a lot of defendants that come before me, but it's not a worry in your case because you have no history. So the real risk is that you're opening up yourself to cross-examination by the state. Based on the colloquy that I've given you thus far, do you have any questions of the court about anything I've discussed or explained to you this morning? All right. After this colloquy, do you feel like you need to take any additional time to speak with your attorneys regarding the decision that I'm going to ask you to tell me in just a moment?
No, thank you.
All right. Have you made a decision in this case whether to testify in your own behalf?
I have.
All right. What is that decision, Mr. Ferriter?
To not testify.
All right. Based on the court's colloquy of Mr. Ferriter, sir, I find that you're making the decision knowingly and intelligently after having had the opportunity to receive the advice and counsel of your attorney. I also find that I've explained to you the potential risk and consequences of testifying in your own behalf on the stand, including the fact that you would subject yourself to cross-examination. Based on all that, I find that you're also entering into this decision with an appreciation of those risks and consequences, and that you understand the same, and that your decision is being made freely and voluntarily. So I accept your decision not to testify as having been knowingly and intelligently, freely and voluntarily made by you. So that concludes the colloquy on this matter. Sir, you may give your attorney back to Mike, and thank you, sir. All right. We are set to start back. Ms. Murad, you're standing. Anything I need to address? Oh, okay. All right. So we're set to start back with, so when we come back at 1 o'clock, the defense will rest. And at that point, I will begin the closing instructions. So we'll immediately move in to closing arguments in the same time limits and deadlines. And time warnings will apply as we put on the record yesterday. Anything else I need to address before we reconvene at 1 o'clock?
No, just, are you going to instruct, or do we start right away? Do you instruct before or after?
Before or after what?
Closings.
No. I instruct before because the attorneys, whether you're the state or the defense, spend a lot of time arguing the law in your closing. So I think it's most beneficial to have the jury be advised of what the law is before they hear your closing arguments.
It's fine. Just
Yeah,
wondering.
that's been my normal practice. I assume everybody's in agreement with that, right?
Yeah, this day has no issue.
All right. Okay. Well, that's the way we'll do it. Anything else I need to address? Yeah. Thank you for raising that so that we can address that now and not delay the proceedings any further. So go ahead, Mr. Wahid. So what I'll do is have you make the motion now and make your argument, but I still want you to make the motion on the record after you've rested, and I'll just say same ruling as made previously, if that's my ruling.
Understood.
Whatever I rule at sidebar or in open court now, that will be my ruling, and that'll be the ruling I'll adopt when you renew the motion.
Understood.
So go ahead.
So first, we're going to renew all of our previous motions and objections that we've made throughout this trial, orally or in writing. And in terms of my second judgment of acquittal argument, it essentially is the same as the first judgment of acquittal argument. The difference at this point would be that the court's now heard from a few extra witnesses, and I think those witnesses, especially Dr. Rappa, give enough for us to make an educated judgment that no reasonable juror could find against Mr. Ferriter. The essential element here that the jury is going to be deciding upon is the criminal intent. The actions are mostly in agreement by both parties. There's a few here and there. It is really a question of, was this being done for a purely torturous purpose, for a purpose of being simply malicious, or for a purpose of just for no reason, unlawfully, in other words, caging. And I do think that we heard from Dr. Rappa, who talked about the history of the child, the different diagnoses, the interaction of the child in terms of the behavior elements, and how that informed the parents in terms of what they then had to do in response to each of those moments. And while we've all been here for only a week, I'm sure it feels like a month, but for a week on this case, they've lived with it for, somewhere in the range of somewhere between 8 and 10 years at least of Ronan's life. So from that perspective, their actions, and we heard it on the video admitted by the state, where Mr. Ferriter said that he was not giving up on this child, that what he was doing here was to try and right the ship, that Ronan kept conducting himself in a manner that was going to continue to get him in trouble. And this, while started when he was young, now he's 14 and it's still going on. You know, where is this going? So the actions taken, and that's the key part of this statute, the intent of those actions was not for a torturous, malicious, or unlawful purpose. It was for a justified, lawful parental purpose. And that's what I believe the jury instructions clearly say, and I think that's the decision upon which the court should grant the judgment of acquittal.
All right, so let me ask a couple questions for you. Do you agree that the standard, again, is at this stage is that no reasonable jury could conclude that the defendant is guilty of aggravated child abuse? That has to be the standard that I look at.
Yes.
All right, so how do you deal with the fact that, and I acknowledge your representation of the testimony of Dr. Rappa with respect to the maliciousness aspect, but in order to get to where you want me to be, then I would have to totally ignore the testimony of Dr. Myers. And so my concern is I have conflicting expert opinions here that ultimately the law tells me I'm not the one to decide between those two. It's the jury, and that they have to decide because there is evidence that both sides have submitted on that issue. And it strikes me as just part and parcel of what the system is all about, that when you have disputed issues like this, the judge doesn't decide it. The judge lets the jury decide it.
I think it's worth the court noting that the opinions on maliciousness by psychologists and psychiatrists are ultimately lay opinions. They're not in the DSM-5. These are opinions that these are their own opinions and observations, but those are not medical diagnoses.
Yeah, and I don't know that I totally disagree with that position, but I don't know that it helps your position on the JOA, because then you have to look at the conduct, you have to look at the circumstances, and those are things that really fall into the penumbra of what a jury would look at in making its own determination. So I don't know that that helps you. I kind of agree with you to some extent that those may be closer to lay opinions than expert opinions, but they've been rendered in this case as expert opinions. But if the jury disregards the experts' opinions, as they are free to do, then they still have to look at the facts and circumstances and make their own conclusion and arrive at their own determination as to whether it was malicious. You agree with that basic precept?
So the part about the experts, I don't agree, in that there was a relevant testimony from them that does help inform the jury, and both experts agreed that the child suffered, there's evidence the child suffered from RAD, reactive attachment disorder, and both agreed that that would have been something that would have happened in those first 17 months or so of his life before he was adopted by the Ferriters. So regardless, both would agree that his behavior is very likely a result of the reactive attachment disorder, and that the reactive attachment disorder was present when he was adopted by the Ferriters. So they didn't create that. So it is a situation where they are now dealing with his conduct completely improperly, but they are dealing with it as they believe parents.
But your own expert testified that the conduct, the response worsened the RAD, the reactive attachment disorder.
100%, but that isn't the question before the jury. The question is, was the intent to make it worse, or was that their attempt at parenting?
Okay. All right. Thank you, Mr. White. Anything else?
No, Judge.
All right. Who's going to argue for the state, Ms. Black?
Yes, Your Honor.
Is Joao or the other one going? Which one's going?
Before on the first JOA, based on the evidence that has come out, this
no,
case
it's the
should
other
be
one.
submitted to the jury, and they're the ones to make the decision as to whether he's guilty or not.
Boom, that's it.
All right. Court's going to deny the second motion for JOA, pretty much for the same reasons that I denied the first one, and that is that I think that enough factual circumstances and enough disputed testimony has been presented that the court cannot decide this as a matter of law, and that it will have to be decided on the facts and the law by the jury. So that's the court's ruling on that. Anything? So what I would ask, Mr. White, when you or Ms. Murad rest, you'll make your motion, stand up, and then I'll say the ruling on the record previously stated applies, and then we'll go into my reading of the closing instructions. Okay? All right, anything else that I need to address? All right. Seeing no responses, I'll give you folks about a 12-minute break. We'll start back up at 1 o'clock sharp. Mark, we have all the jurors here? I have all the jurors. Okay.
I know we put some evidence in yesterday. I'm just getting the date timestamps on those. And then I've got part of evidence 16, there were 3.
Do we need to go over what has been accepted and received by the court just as a matter of caution for everybody? I mean, I'm happy to do that.
Yes, and Your Honor, just for the record, I know we had some discussion.
Oh, now you're willing to do it. You didn't do it before.
Defense's large exhibit. I did let the defense know that in addition to the sustained objections yesterday that Your Honor ruled upon, there was 2 additional videos that I objected to, and it's my understanding that they're going to modify the exhibit.
Was that 18, Exhibit 18?
And replace that exhibit. And then by agreement, there were a couple dates that we wanted to put on the record. There was one date that the state wants to put on the record, and then a couple that the defense wants to put.
Okay, so I have states exhibits 1 through 22 in evidence. I won't state whether they're over objection, without objection, or whatever, but 1 through 22. Does that, Madam Clerk? All right, so for the defense, and just make sure I'm correct here, Madam Clerk, I have exhibits 2, 4, 7, 15, 16, 17, and 18 in evidence. And as for ID only, I have 1, 3, 5, 6, 8, 9, 10, 11, 12, 13, and 14. Does that comport with yours, Madam Clerk? All right. Mr. Wyatt or Ms. Murad, is that any issues with that? Okay, all right, so that takes care of that. All right, we'll be in recess until 1 o'clock, and then we'll start with the instructions. Ms. Black, before I step off, these are the new reprinted ones? Yes. All right, I'll look at them just to make sure they are where they need to be. Okay, thank you.
Judge, if we can just discuss the defense exhibit number 17. I never received that. I think defense is making changes to it.
Use the microphone.
We don't have a working microphone. Oh, they were getting new batteries.
Judge, we, based on the state's objections, it was only over 4 videos. We agreed to remove them. Because it's a 14-hour video, it takes a minute to remove them and then re-render it. So we will submit that into evidence, but it might have to be after closings.
Okay, all right. Fair enough. Does that answer your question, Dana? Okay, all right, court will be in recess until 1 o'clock.
Okay. So they went over jury instructions and went back and forth about the charges and stuff like that. Seems like lesser charges. The jury was not there for any of that, by the way. And Timmy, some people say Jim Neutron or Timmy Neutron, whatever they call him, he's not testifying. He declined. So it almost sounds like it sounded like they have more evidence to present. I don't know. Are they gonna do that after the show some video after? I don't know. I just hope they close it and we can hear closing arguments. Get this thing over with. Skyla, happy birthday. Happy birthday. Callie Sandy, thank you so much for the super chat. Says, I would love to hear this prick justify his actions. He'd be ripped apart. Meow. Love email, mods, and chat. Thank you. Pumpkin Porter, thank you for the membership. Timmy Turner. That was a song? Timmy. I don't remember. Timmy Turner. So with the poll, let's see here. 591 votes. 50% say 5 years. There was somebody in the chat, CY, saying he thinks less. 10 years, 27%, and 15 years, 13% say 20 or more years, 11% say. I had somebody in one of the comments yesterday say that this was just bad parenting, that they shouldn't be locked up. They were furious. I mean, there's some people. This is like beyond corporal punishment, but some of these people in the corporal punishment, they would do something like this, like put the kid in a lock them up for a couple hours or something, and some sort of contraption, and that's how they parent. Some people feel like they should be able to do what they want when they're parenting. But the box thing is, it's another level. But yeah, I don't think he's getting a long time. The plea deal was 2 years, his offer that he turned down. There's a lot going on in the world. People saying this one's lying, people saying that one's lying. With this Israel, Palestine, Iran, Hamas. With a piss bucket, right? That's true. But they were trying to argue that he had uncontrolled bowel movements and stuff. Still. Oh, let me see what else is in the meantime. What's going on while we wait? Oh, they're talking about Hezbollah. Oh, Carly said this. I guess they're going to join in this. Well, I don't know if I should really talk about this now because we're going to save it for the other channel. But Qatar in talks with Hamas, Israel to swap hostages for prisoners. We can look at some of the live feed too, see what's going on out there. By the way, too, like I said earlier in the stream, if you haven't checked out my backup channel, iCkEdMeL Clips, check it out. I'm posting highlight reels of the trial. If you missed parts of it, we're also covering what's been declared a war now. Israel and Hamas, Iran. So we're covering all that kind of stuff over there when I join over there as well.
Since Russia is unprovoked and all-out
invasion. By the way, you know what I was reading this morning? That said Putin... Oh, let me cover that too, Glory. That said Putin is terminally ill. Do you know that? They're scrambling and trying to find a replacement. I didn't know that guy was terminally ill. Vladimir Putin. Vladimir. Damn. His time's finally coming, huh? After all that ish. Putin. I saw people in the chat saying something about Turtle Boy. I don't know what that situation is. Jennifer Coffindaffer posted it on her Twitter. I don't know anything about the guy, so I don't have anything to say about him. But a lot of people are talking about him because with the Karen Reed story, they said that he has a lot of information, that he's been covering it and stuff. I haven't covered Karen Reed. I don't know. People keep telling me I've thought about it. Anyway, this is what Jennifer Coffindaffer had to say. She's like, former FBI. People have mixed feelings about her too. She said that it sometimes takes a while for justice to come, but it's on its way. Earlier this morning, I was advised that Dr. Turtle Boy was arrested on multiple state charges. I have no idea what those charges are. I never revealed that privately via email. Iden currently threatened. Oh, shoot. Is that his name? I didn't know. I'm just reading what this woman posted. Threatened not only me, but also my family and my children. See, this is like all some drama stuff. They're not in court right now. Oh, Karen Reed's in court. Is that what you're saying? iCkEdMeL heard they're demonetizing channels that talk about the war. Are they? Why? Merely because of my initial post that I agree with the state's position that there was probable cause to believe Karen Reed killed John O'Keefe. And I've seen people put in the hashtag free Karen Reed. I guess there's a thing where people have different opinions and taking different sides. Really shame that this is the state of true crime community. Oh, that a person can disagree about a case and be relentlessly stalked and maligned. Ooh, man. To the relief of many, especially those he continues to falsely accuse of killing Officer O'Keefe, justice is literally knocking at the door. Help those subscribing and following him will take a deep dive into who he really is. His lack of credentials, what he has said in his blogs that have hurt so many, his past history with the law. I don't. And then I guess he's having an arraignment. Damn, she's posting the arraignment documents. Ooh. I mean, I don't know if it's true. I'd feel some type of way too if somebody came from my family, but I don't know. Oh, we're gonna be able to see video? Are they setting that up? And as far as the person that said they're demonetizing channel roles, I don't think they're gonna demonetize channels. They might demonetize videos. I could totally see them demonetizing whatever, like the topic. If you're talking about the topic, certain things. I actually just had a video. Well, I don't know. Let me not speak too soon. Let me see. I think it depends how you how you cover and talk about it and what you're showing. It really depends. Let me check the backup channel real quick. It's really hit or miss. I really wouldn't be surprised if they demonetize it. I remember at one point during COVID, they demonetized all the COVID videos. You know, they just, they felt, and then they changed their stance on it and they remonetized. And that video I did this morning, oh, they blocked it because of Trevor Noah. I'm not ever covering you again, Trevor Noah. Blocked the video everywhere. I'm trimming it out so we can put it back up. Trevor. Yeah, see, like the last video I did about the war Hamas, they age restricted it. So yeah, I totally understandable. They're probably not gonna, Fire says Covered Effort was drunk on STS. Oh, I know that show. And Aiden left because she was being vile towards him. Oh, so there's a whole bunch of drama. Yeah, I don't know. I don't follow. I do not follow all this stuff, bro. I don't know. Yeah, DI guys out of Israel. We might be able to get to see some. This would be interesting if we get to see some video. I'll just take a screenshot of this. We'll see. I don't know. Well, I mean, we'll probably have a better view if they do, like, in a minute. Let's see. Last one said they've been saying he's terminally ill for 2 years. I doubt it. Oh, yeah. Maybe it's a trick. Vladimir. Yeah, BL. Yeah. Keep it to the backup channel. Oh, yeah. Oh, so they're going to do a presentation. So we're going to be able to see the presentation. That's cool. At least we get something. Around 1:30, 1:40, I'll have to step away for a bit. Hopefully I don't miss too much. I mean, I'll leave the stream running, but, That case is a mess. Yeah, I heard it's people tell me it's complicated. 1:40, I have to take a screenshot here. Yeah, update the thumbnail in a bit. So I think they should be going to closing arguments. I think that'll be next. Oh, they put a video of him being arrested too? Oh man, so it's in the oh shit. Oh man, let me see something. Oh, it is in the news. Oh, mass blogger Total Boy in court on witness intimidation. Oh, it's been on NBC. Oh my God. What is this? What did I stumble into? Oh, this is a live hearing right now? Wait, what is this? That's not for him, right?
Attending the rally. Juliana Nagel, 25 years old, lives, I'll omit her address, in Canton with her 2 parents and 2 siblings. Juliana was home with her mother at the time of the protest. Juliana and her brother were present at 34 Fairview Road and have been interviewed by investigators. Identified the residence as her home. Kearney made a statement to get the attention of her neighbors. He described how O'Keefe was beaten to death at a house where Juliana was present. He stated at any point, Julie Nagel, you can come out at any point. Nothing is stopping you from telling the truth. You know what happened that night. He continued to state, you can't get away with it anymore. Too many people know. You're going down with them. Nothing is stopping you from coming forward and telling the police what happened. Kearney claims Nagel lied to investigators about her observations the night of O'Keefe was killed and is complicit in the cover-up of a murder. Kearney stated, you might as well tell the truth and let the world know what happened. Neighbors, maybe you guys could help us pressure them into...
Who was he accusing?
Pressure them into this. Julie Nagel was involved with, was at the murder of a Boston police officer. She knows what happened and she is actively involved in the cover-up. She should not be able to walk around town like none of this happened while an innocent woman named Karen Reed suffers the consequences of her silence and her complicity. The truth will set you free. Kearney is in front of the residents for approximately 10 minutes. At the conclusion of the speech, he stated the next location is the home of a Canton Police Department Deputy Chief, Thomas Kelleher. While traveling to the next location, Kearney stated Julie Nagel's house was
about to cover the trial and all this crazy shit.
And clearly, the statements he made there, Judge, is about as far as you can go to intimidating a witness as to what his intent was. During a recorded interview on the YouTube account WristFlex, dated August 2023, the defendant made comments about his influence on the jury pool. I want the world to know what happened here. They want the story to be silent, nobody knows about it. They want to be able to find a jury pool that has never heard any of this shit before they can manipulate them the way they've manipulated everyone else, and I'm not allowing it. Not allowing them to do that. Happy to do it. Elite mass corruption, Turtle Boy, 104 mark. Based on the foregoing facts that I've read, Judge, it's clear that the defendant committed the violation of Chapter 268, Section 13B, which is intimidation of a witness and witness interference with Juliana Nagel. I will not recite the paragraph that I recited earlier as to what the language of the statute is. And for this reason, Judge, on the second complaint,
thank you, Andy T.
1151, we're going to be requesting those same conditions of release. Does I have about perhaps another hour going on wants to take a break or keep...
You guys want to watch this later? See what's going on with this shit?
Let me ask you this.
I might have to have because somebody call me in and fill me in what the hell's going on. After.
So,
I mean, I don't want to get into all this YouTube stuff, this YouTube drama stuff, but
haven't you covered that?
I was planning on covering Karen Reed.
There are, Judge. There are other witnesses, so I would ask that those conditions apply to each of the docket numbers. The facts are fairly similar, but as there are different witness/victims in these cases, the specific facts vary. But they're generally the same content as the two I read.
Issue, which means that the clerk magistrate found probable cause to issue the complaints. So that's been established.
We need to watch this whole thing. We missed out on it.
The alleged victims in the various cases were to be named, then we would.
And I don't condone this stuff too. I mean, I don't know what really happened, but like, I don't know, reaching out to people, like, or showing up to their place, and how, I don't know what's up with YouTubers taking things and getting crazy and shit, and all this conspiracy shit. I don't know if he did that, but I just, these other situations that I've been in myself, or some of these other people online right now go through some crazy conspiracy stuff, accusing YouTubers of all kinds of stuff, or people. I don't understand it.
What is your position with regard to the Commonwealth's request for cash bail in the amount of $1,000 and the various conditions?
Yes, Your Honor. As
Well-
far as the bail, we're asking for release on personal. He has no record. He lives with his family in Holden, and he has 2 children that he supports.
You got kids too? Oh God, man.
What we're providing here is that we don't believe that because of his record or because of his commitments that he would be a danger of flight or creating a
Well, his next live stream is going to be lit.
in terms
It's
of
probably going to get viewers, subscribers. Everybody's going to go watch now, I guess.
conditions.
They're going to be lit.
Mr.
You're going to make that bail money back too.
He is a news person who is using his First Amendment rights to cover a story.
First Amendment shit. Here we go.
Now, I know that he is doing it through YouTube and social network, but there are a lot of people who do this. And he is requesting that he still be able to do this news coverage.
Oh.
He vehemently denies that he's intimidating or harassing anyone, that the trooper involved is a public figure, that there is a potential selectman involved, that he goes to meetings, and he feels as if that he should be allowed under his First Amendment right to pursue his story. Now, as we go through it in terms of the threats, I just would like to point out that when I read the statements that the prosecutor stated, I see opinion. I don't see threats under the way my client is acting. I said from the beginning, I don't want to go to trial. Most people don't want to go to trial. That's an opinion. That's not perceived.
He said he didn't want the Cameron Reed case to go to trial.
Okay. But still, it's an opinion, and he put it out on the web. It's really important for the people in Norfolk to know about this story because the jury pool was chosen from there. Again, opinion. Again, the internet allows for that. I'm sure that
They honking outside?
I would hope that if any of these statements would have violated YouTube policy, they could have contacted that and had it all taken down.
YouTube don't do shit though. Come on.
In
You know,
addition, I would provide that this is a lot of reports, and for some of these conditions to apply, such as controlling his followers, not sure how you do that.
control the followers.
I would believe that if he were allowed to continue to pursue the story with his bail warnings, that the police could access or take a look at further events that he does. Meaning that if he calls for one of these rolling rallies, someone will give a call, they can go out and they can determine whether or not it's intimidating or if there's a charge or a plot. I mean, that's what I'm arguing, to allow the First Amendment to go forward and to allow the prosecution to continue to monitor this.
Rise. Court is back in session. The Honorable Judge Howard Coates presiding.
All right.
Good afternoon, everyone.
So
You
we
may
can
be
come
seated.
back to that later. Check it out. What's going on? So he's denying that. Like I said, I don't follow this stuff.
All right, court is back in session on State versus Ferriter. Let me have appearances, please.
On behalf of the state, Brianna Coakley. Karen Black on behalf of the state. On behalf of the defense, Priya Murad with Cora Mohammed and Mr. Ferriter.
All right, all sides ready to proceed. Anything the court needs to address before we have the jurors brought out?
Judge, I would just ask, in light of the fact that a number of people from the family sort of on both sides are present, that the court admonish the gallery that regardless of what is said during closings or the verdict, that there is a level of decorum that has to be maintained, or we may be looking at a mistrial.
All right, so let me just state kind of the obvious. When you're in a court proceeding in the gallery, during the closing arguments, whether you feel one way or another about the case, you're to keep your emotions suppressed while you're in the courtroom. You're not to have any outburst of any kind. That especially goes for the closing arguments because there may be things that are said that some of you will agree with, some of you will disagree with. It especially holds, though, with respect to the verdict. Once the verdict is read, everyone is to reserve their emotions as best you can. Any outbursts, if you feel like you need to have an outburst, you You go outside the courtroom and scream, yell, do whatever you want, but not in the courtroom in the presence of the jury. We haven't had any issue with that during the 8 days now that this proceeding has been going on, so I don't anticipate that there will be any issues with it today. But in any event, you've been advised of the proper decorum in court, and I expect everyone to abide by that. Anything else I need to address before we bring the jurors out? All right, Mark, you may bring the jurors out. All rise.
Hold aboard. I really don't know the Turtle Boy stuff, man. Maybe we'll check it out later.
All right, everyone may be seated.
Just a regular folks show up at court to protest because they believe we take the war.
All right, ladies and gentlemen of the jury, welcome back. I trust everyone had a good evening. As I advised you yesterday, the start time was later today, 1 o'clock for you folks. So that what that means is you will not be getting a lunch break. I'm presuming that you already had that before arriving. In any event, we are still in the defense portion of the case. After the defense portion of the case, we'll then be moving to closing arguments. At this point in time, does the defense have any further witnesses to call?
No, Your Honor. At this time, the defense rests and renews any previous motions for judgment of acquittal on prior grounds.
All right, court notes that the defendant has rested and renewed any previous motions filed with the court and heard by the court. At sidebar, the court's rulings with respect to all prior motions remains the same and as stated on sidebar in an open court. All right, so ladies and gentlemen, that concludes the state's and the defense portion of the case. So the evidentiary portion of this trial has been concluded. What that means for you is we will be moving into the closing arguments phase of the case. Each of you are having passed out to you what are called jury instructions. And these instructions I'm going to be reading to you in just a moment. They're the instructions on the law that you will use and need to resort to decide this case. I will tell you as I read the instructions, don't feel like you've got to memorize anything because you're going to be able to take copies of these back into the jury room with you to review during your deliberations. The only thing you won't be able to take back is the verdict form. After I've finished reading the instructions in the verdict form, before you go back into the jury room, I will have you remove the verdict form because we only send one verdict form back into the jury room. We never want to have a situation where competing verdict forms are coming out of the jury room. So we deal with that by making sure you only have one verdict form in which to render your determination on. Okay? All right, so with that, let me begin with the instructions that I'll be reading. I do ask that you bear with me. I will be reading the instructions. Listen to them carefully, but again, don't feel like you got to memorize them because you're going to get copies of them. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I'm about to give you. Timothy Ferriter, the defendant in this case, has been accused of the crime of aggravated child abuse and false imprisonment and neglect of a child. To prove the crime of aggravated child abuse, the state must prove the following two elements beyond a reasonable doubt. 1, Timothy Ferriter willfully tortured RTF or maliciously punished RTF or willfully and unlawfully caged RTF. 2, RTF was under the age of 18 years. Willfully means intentionally and purposely. Maliciously means wrongfully, intentionally, and without legal justification or excuse. Maliciousness may be established by circumstances from which one could conclude that a reasonable parent would not have engaged in the damaging acts toward the child for any valid reason, and that the primary purpose of the acts was to cause the victim unjustifiable pain or injury. It is not a crime for a parent of a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from the discipline. If you find that the state proved beyond a reasonable doubt that the defendant was not a parent of RTF, or if you find that the defendant proved beyond a reasonable doubt that the defendant's physical discipline on RTF was not reasonable for misbehavior under the circumstances, you should find him guilty if all the elements of the charge have been proven beyond a reasonable doubt.
Better? Cool.
To prove the crime of false imprisonment, the state must prove the following two elements beyond a reasonable doubt. 1, Timothy Ferriter forcefully, secretly, or by threat confined, imprisoned, or restrained RTF against his will. And 2, Timothy Ferriter had no lawful authority to do so. Secretly means the defendant intended to isolate or insulate RTF from meaningful contact or meaningful communication with the public. To prove the crime of neglect of a child, the state must prove the following three elements beyond a reasonable doubt. 1, Timothy Ferriter willfully or by culpable negligence failed or omitted to provide RTF with the care, supervision, and services necessary to maintain RTF's physical or mental health, or failed to make a reasonable effort to protect RTF from abuse, neglect, or exploitation by another person. 2, Timothy Ferriter was a caregiver for RTF. And 3, RTF was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of aggravated child abuse is child abuse. To prove the crime of child abuse, a lesser included crime of count 1, the state must prove the following two elements beyond a reasonable doubt. 1, Timothy Ferriter knowingly or willfully abused RTF by intentionally inflicting physical or mental injury upon RTF, or committed an intentional act that could reasonably be expected to result in physical or mental injury to RTF, or actively encouraged another person to commit an act that resulted in or could reasonably have been expected to result in physical or mental injury to RTF. And 2, RTF was under the age of 18 years. It is not a crime for a parent of a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from the discipline. If you find that the state proved beyond a reasonable doubt that the defendant was not a parent of RTF, or if you find that the state proved beyond a reasonable doubt that the defendant's physical discipline on RTF was not reasonable for misbehavior under the circumstances, you should find him guilty if all the elements of the charge have been proven beyond a reasonable doubt. Willfully means intentionally and purposefully, and mental injury means an injury to the intellectual or psychological capacity of a child as evidenced by a discernible and substantial impairment in the ability to function within the normal range of performance and behavior as supported by expert testimony. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if 1, the defendant had a conscious intent that the criminal act be done, and 2, the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said, and some things you should consider are as follows. 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? And 7, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You've heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true and understands the duty to tell the truth. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness, and a juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Now, there are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict, and they're as follows. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice, and there is no reason for failing to follow the law in this case. And all of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. And 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job, and I cannot participate in that decision in any way. So what I would ask is that you please disregard anything I may have said or done that made you think I preferred one verdict over another, as that would not be the case. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, and that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing for your convenience. The necessary verdict form has been prepared for you, and each of you have a copy of it, and it is as follows. So, as I indicated, you'll take one of these verdict forms into the court or to the jury room for deliberations, and they begin as follows, or it begins. We, the jury, find as follows, and the first count that you'll be asked to address will be count 1. You're basically given 3 options under count 1. The first option is guilty of aggravated child abuse as charged in the information. If the unanimous determination of the jury is that that's the appropriate determination, then you check that box and move on to count 2. If, however, the unanimous determination of the jury is that not to check the first box, then you move on to a consideration of the second line for guilty of child abuse, a lesser included offense. And again, if the collective unanimous determination of the jury is that that's the appropriate box to check, then you check it and move on to count 2. If not, then you will move to the third box for not guilty. And if, again, that is the collective unanimous determination of the jury, that would be the box that you would check. Once you've checked a box for count 1, you will then move to a consideration of count 2. In count 2, you have 2 options. 1 is guilty of false imprisonment as charged in the information, or 2, not guilty. And so whatever the collective unanimous determination of the jury is as to count 2, you'll check the appropriate box. And once that has been done, you will then move on to a consideration for count 3. Count 3, you also have 2 choices. Guilty of neglect of a child as charged in the information, and not guilty. And again, whatever the collective unanimous determination is of the jury, you will check the appropriate box. Importantly, you only check 1 box for each count. So just keep that in mind as you go through the verdict form. At the end, once the foreperson is selected, that person will date the verdict form and sign where indicated on the verdict form. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. And so by the way the verdict form is separated, you would be returning a separate verdict as to each count. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime.
Let me just tell you, if you're very sensitive to graphic like images and stuff, just be careful scrolling Twitter, because there is stuff everywhere. And the thing with that is if somebody follows you but you don't follow them, it just like pops up in your feed and stuff sometimes. So like I was just scrolling, there's this like picture of like dead kids. I mean, I'm talking, I don't know, 3, 4, 5. And I'm just randomly scrolling. I'm just looking at my notifications. I don't follow this person, but you know, I mean, I know what it is. I know we're gonna see that kind of stuff, but it's like, damn, bro. Just on another one too. Yeah, just be mindful. Oh, it's because I'm tagged. They tagged me in it. Yeah, I mean, I can't show that anyway. It's bad. It's really, really bad out there. Holy moly.
Jury at this point been inadvertently exposed to any contact or exposure to any media, whether it's video, television, print media, or anything like that?
Oh, I'm sorry. Did I
Anybody
interrupt?
exposed?
I kind of interrupted. Huh?
All right, so let the record reflect that no one has indicated any inadvertent exposure to any media coverage during the conduct of this trial. So that takes us to the last thing that I will need to tell you at this point, and that is that the attorneys.
Can I come sidebar for a moment?
You may.
All right, let's get on with the closing arguments. Come on. Yeah. I'd even be careful. Yeah, if your kids are around you and you're scrolling Twitter, or if you just have it open, or if they have Twitter, I don't know. Anything can pop up. Just be real cautious. Be real cautious, especially with your kids and stuff. All right. So I'm guessing the prosecution is going to start. I'm going to have to listen when I'm in the car, I guess. Let me tweet this out. I put a poll, by the way, in the chat. So if you want to participate, it's how long for verdict. I should have said the verdict, but whatever. 1 to 2 hours, 3 to 5 hours, 6 to 9 hours, 10 hours. 40% or 41% say 1 to 2 hours. 44% say 3 to 5 hours. 9% say 6 to 9. It's kind of changing a little bit. The 5% say 10 hours. I don't know. Yeah, that's true, Kitty. If I had to pick and guess, I don't know. I've always got on the lower side, and it's taking longer than I expected. It kind of surprised me. I'll go with 3 to 5 hours. I'm gonna go kind of in the middle. I think there's gonna be some arguments about whether it's aggravated child abuse or child abuse. I think the lesser one was child abuse, I think.
Okay, so as sometimes happens after the court has read the instructions, it becomes apparent that there may be an additional instruction that either of the parties may want to have read. So that has occurred here, and so in order to make sure that I properly read to you any additional instructions that were not part of the original packet that were provided to me, I need to take a recess for about 5 minutes to have them print out the additional instructions, and it will change the form of the verdict form. So I'll go over the additional instruction and the form of the verdict form, so to make sure that you have everything that you're going to need to know. I'm not correcting anything that I've already read to you. I'm just adding an additional instruction, which will also make for an addition to the verdict form. So we'll take a very short recess for 5 minutes, and then once I get the new instruction in front of me, we'll begin with reading that one. All right, everyone may be seated. So what I'm going to do in regard to addressing your request for an additional instruction, Mr. Waheed, I'm going to read when there are lesser included crime instructions. Let me get back to that one.
They know it's coming. That's why.
Yeah, I'll read 3.4 again, and
No,
after I read
Susan,
that,
of the war, the Israel.
You'll just need to include what is the child neglect is the lesser to what? Child abuse?
Culpable negligence is the lesser to child to neglect.
So which is culpable negligence? So lesser. It's in the count one. Count three. Okay, so 3.4 needs to be changed to include that culpable negligence is a lesser to count three. So that I'll advise them of that. I'm not going to reread the lesser that I've already read. I will only read them the additional lesser dealing with culpable neglect as to count three. And then I'll go back over the verdict form, and they'll be provided with a new copy of the verdict form that will, that I can at least explain to them. They can go back to that. All right, does that take care of everything? So just print those out to, can you open up Judge Rowe's office? They're going to print to that, so I have copies.
Yeah, the defense needs to have the female woman doing the closing, unless they're going to
Court will
tag
be in
team.
recess for probably no longer than 5 or 10 minutes, but as soon as the forms are ready, we're going to reconvene to get things going. All right, I'll be in recess for a few minutes.
Court's in brief recess.
Sometimes they tag team the attorneys and stuff, and they'll do half and half or whatever amount of time. Black Lives Matter is now trending. There's a whole bunch of drama going on with this. I mean, the murder and deaths is not drama, but like as far as like online, yeah, it's like a whole bunch of all this stuff. Ooh, Lord Almighty, what a mess. Yeah, be careful with Twitter. Be careful, man. There's all kinds of. I just saw some stuff I didn't want to see. Newman begins his sentencing with, "Does anyone have a calculator?" Brianna, that's funny. Does it really? Can they object during closing? I feel like they have. I think usually they really I mean, I've seen them do it during opening. They really try not to. They're not really supposed to, but I mean, I don't think they really should, but they do. I don't know what the rule is on that, but I've seen them do it. But they really, it's not often. It's kind of like, to me, it's kind of like glove. I don't want to say gloves off, but there's less of a standard with the opening statements. I don't think this guy's walking out not guilty. They're gonna find him something with the lesser charges or something like that. So I'm gonna say I don't think they're gonna get him for aggravated child abuse. Just a guess. I don't think aggravated child abuse, but maybe the child abuse. I believe they're still married. She's there in support of him, I believe. I didn't know there was a setting like that. Crimes have consequences. They should probably have that on by default, maybe, but that would probably kill their impressions. Aggravated Mel is hitting. Hoax was talking about that if it's just child abuse. What did you say earlier? I think you said it's like 5 years and something probation, or was it 3 years? Well, the aggravated child abuse, I think, is like the intent as well. I mean, just like, I guess this case is different, but just like hitting your kid, just because you said hitting. So if you just hit your child, which, you know, I'm not into corporal punishment, that's not just going to be assumed aggravated child abuse. But I mean, I guess with regards to this case, did they? I mean, we couldn't see any video. What did Ronan say? Did Ronan say that he would slap him or something? Oh, the verdict countdown. I actually have to dip out of here now. I'm gonna let this thing go. I'm gonna try to figure out I think it's an app. I think it was kind of a pain in the butt to set up last time. Let me see if I can find it. Okay, countdown. Okay, I think let me do a test. Let's see. Yeah, we're gonna have to do a verdict countdown. Oh, maybe I could just do it in here. Start, pause, add time. That work? Oh, it does work. Start. Okay. Okay, so that works. Actually, it's not bad at all. I thought it was the other time. One of the other apps was like really annoying. Maybe they updated it. Okay, so I'll just reset for now. All right, cool. So I'll hide that for now. So we'll do the timer when the time comes. Drake Main says, "Do you think if Aiden or Ethan's parents had locked them in a room, those other children would still be alive?" Oh, shoot. I don't know. What a question that. I don't know. Maybe he might have killed his parents or something though, Ethan. I don't know. I have no idea. That's an interesting question. You know, the other day we were watching this video on the backup channel where we were just watching some fun streams, and there was this little kid over here. He was 3 years old, and he was next to his mother, and I don't know what he was trying to do. Like he was just like misbehaving, and the employer, I mean the employee, the person that works there, I think it was maybe the manager, because the kid was kind of acting out, grabbing stuff, and he's like, "Hey, like you can't do that," and the kid was like, "F you, bitch, F you," like just going off, and the mother's like, "There's nothing I can do." He's like, "You're just gonna let your child? There's nothing I can do." And she's like, "I can't hit him because that's child abuse. So I just gotta let him do what he does." He said, "F you." I was like, "Wow, that kid was wilding, man." Ethan Crumley. Prime Crime Junkie. Thanks for the super chat. Why did the state offer only 2 years to this piece of S? I don't know. That's a good question. Maybe they just kind of wanted to get it out of the way. Maybe they figured they weren't going to be able to get 30 something years on this guy. That kid was a trip. Yeah, he said, "Shut the F up." He was like 3 years old. I don't know how old the kid was. All right, I have to head out of here. I wanted to make sure the volume was good though when these people start talking, and they would take another like 5 breaks and stuff. Jesus. Um, or I'll just give it a little extra bump. I don't know how it's gonna be. All right, I'll be back.
Rise. Court is back in session. The Honorable Judge Howard Coates presiding.
All right, everyone may be seated. All right, so both sides looked at the revised 3.4, the lesser included 8.9 for culpable negligence in the revised verdict form.
Yes.
Are all sides in agreement with the form of these documents?
Yes, yes, Judge.
Okay. All right, you may go ahead and bring the jury out then. All right, so what I'm going to do is have them leave their jury instructions, and I want new sets printed for each of the jurors that go back. Oh, you've already done that, so that's done. Everything's been replaced. Okay, all right, good enough. All right, we're set then.
Jury entering.
All rise. All right, everyone may be seated. All right, so I'm going to ask each of the jurors to turn to the instruction for 3.4. That has been modified slightly to add an additional lesser included. And I'm only going to read the part that I did not read previously because it wasn't in the draft that I had. So bear with me as I read the edited version of 3.4. The lesser crime indicated in the definition of neglect of a child is culpable negligence, which brings me to adding an additional instruction for culpable negligence, which is 8.9. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. One, Timothy Ferriter exposed RTF to personal injury, and two, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows an indifference to the rights of others as is equivalent to an intentional violation of such rights. I'm also going to have you turn to the verdict form because there's a revision to that from what I previously explained. Again, I'm only going to go over the portion of the verdict form that has been edited since I last explained it to you. So when you go to the verdict form, I ask you to go to the portion that deals with count 3. As you recall, the original had guilty of neglect of a child and not guilty. Well, there is a lesser included for count 3 that you will also need to consider if you, in your unanimous determination, determine that the defendant is, there's not enough evidence to provide for a determination of guilt as to the higher charge, you then will be asked to consider whether there's enough evidence for consideration of guilty of culpable negligence, which is a lesser included offense. And as before, if you find that there's not a basis in your collective determination to check either of the first two boxes, you'll then go to consideration of the third box for not guilty. And again, as with all of the counts, you're to check only the box that represents the appropriate collective unanimous determination of the jury and only one box per count. Okay, so that concludes that. So now the attorneys will have an opportunity to present their final arguments. Please remember that what the attorneys say is not evidence or your instructions on the law. However, I do ask that you listen closely to their arguments because they are intended to aid and help you in an understanding of the case. Each side will have an equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. So that concludes my reading of the instructions to you on the law. With that, is the state ready to proceed with its closing arguments?
Yes, Your Honor.
All right, Ms. Coakley, you may proceed.
I want to start by thanking you all for your time and attention. I know this process has been a longer one than any of us estimated, and at times, a lot of the time, it can be tedious. But this process is an important one, and the decision you're about to make is an important one. From the outside, the Ferriter family looked in a lot of ways like an ordinary family. 2 parents, 4 children. The kids go to school, there are activities, the daughters have bedrooms, normal, ordinary to the outside. But what has been established, what has been proven through the course of this case is what was happening inside that house was anything but ordinary. We learned that, we learned that over the course of the time that Ronan Ferriter was in Jupiter, Florida in December 2021 through January 2022, he was subjected to treatment by his parents, including his father, Timothy Ferriter, that was cruel, heinous, and malicious. That under or behind the facade of an ordinary family, there was the treatment and isolation, the systematic isolation and confinement of Ronan Ferriter when he was 14 years old, in that room, in their garage. And that's why we're here today, because this treatment, this systemic way in which he was forced to live is a crime. Now, I want to talk specifically about the law in the case, and you just got it from the judge, but I want to talk for a few moments about some of the specifics and explain it. You heard that your job, the rules for your deliberation in this case, your duty is to determine whether or not the defendant has been proven guilty or not. It is not your job to make a determination if he is found guilty, what, if anything, the punishment should be. That role is left to the judge. And so that means that everyone in this room has a very specific job. The state has a job, the defense has a job, and the judge has a job. And you, as a jury, are here to answer the specific question. Did the state prove its case beyond a reasonable doubt? And in answering that question, the law tells us that your verdict cannot be influenced by feelings of prejudice, bias, or sympathy. So if you're back there and you feel that, I feel bad for the victim or I feel bad for the situation that the defendant is, that is not something that can influence your verdict. Now, in applying the verdict, there are 3 questions or 3 crimes at issue here. I want to take a moment to kind of talk about each one of them. I'm going to go backwards, count 3, and then count 2, and then count 1. So count 3 in this case is child neglect. And basically, there are 3 elements that the state has to prove beyond a reasonable doubt. Elements 2 and 3 are not really in dispute in this case. The child in this case was under the age of 18 years old. He was a child. You heard that during the time period that's at issue here, he was 14 years old. And the defendant was his father. And in Florida, a person that is a father is a caregiver. So 2 and 3 are not really at issue. Now, to prove element 1, we have to show that he willfully or by culpable negligence failed or omitted to provide Ronan with the care, supervision, and services necessary to maintain his physical and mental health. And we're going to go in detail, again, as we've done throughout the entirety of this case, about what the evidence, about how it shows, how it proves that there was neglect. But you heard from Ronan and also from the expert witnesses in this case that they did not try to address any existing mental health issues from at least 2019 was the last time any of those were addressed by a professional. And instead, what they did was systematically isolate him and provide no treatment and have him live in a way that the experts told you would be neglectful and detrimental and abusive to any child. Now, count 2 is false imprisonment. And to prove that, we have to show that the defendant forcibly, secretly, or by threat confined or restrained RF against his will. And so, confined, imprisoned, or restrained. Here we have direct evidence of that. You can hear over and over and over again, and we went through every single day that we have on video. In the room and lock the door. The second element is that he had no lawful authority to do so. There is no lawful authority. There is no right in order to confine a child like this. That's talking about like if you're a police officer. Did you have the lawful authority to arrest someone and put them in jail? That would mean we wouldn't be able to prove that. But the defendant in this case has no lawful authority to do that in the manner that he did. And we have to prove that it was against Ronan's will, and we had his direct testimony as to that. Now, I want to talk about count 1, which is the aggravated child abuse. There are 2 elements to aggravated child abuse. The first is that he willfully tortured, maliciously punished, or willfully and unlawfully caged RF. And it's important to note here that these are ors. So it's in the alternative. It doesn't have to be all of those. It can be any one of the 3. So if you find that we've proven beyond a reasonable doubt that he willfully tortured, then we've met element 1. Or instead, if you find, based on the testimony of Dr. Myers, that it's actually malicious punishment, then that is proving count 1, element 1. Or if you find that based on the circumstances and where he was kept, locked in that room day after day, that's willfully and intentionally caging, that's enough. And then we have to prove that he was under the age of 18, which there isn't much dispute here because he was 14. Now, the courts or the law gives us a definition of what malicious means, and that applies to one of those alternatives, which is malicious punishment. And that means that he wrongfully, intentionally, and without legal justification or excuse, it may be established by the circumstances. So in jury selection and opening statement, there was a lot of discussion about how do you know someone's intent. The law is that you can look to the circumstances. You can make reasonable inferences from the evidence. And it's from the circumstances from which one can conclude that a reasonable parent would not have engaged in these damaging acts towards a child for any valid reason, and that the primary purpose of the acts was to cause unjustifiable pain or injury. Now, you also got an instruction as to reasonable punishment. And in Florida, you can find the defendant guilty if you prove that we have proven beyond a reasonable doubt that the defendant was not a parent, which is not the case here, or if we've proven that the defendant's physical discipline of RF was not reasonable for misbehavior under the circumstances, not reasonable. If you find that it was not reasonable, you have to find him guilty. So I want to talk for a second about how this instruction applies to aggravated child abuse. This instruction is talking about corporal punishment, right? And we talked in jury selection about spanking a child or not spanking a child. There are circumstances in Florida where it is permissible to use corporal punishment against a child, but that has to be reasonable corporal punishment. So an example would be spanking a child.
Overruled.
Right? And so when we're evaluating whether or not this applies, about whether or not something meets the definition of reasonable corporal punishment, we look, 1, is it reasonable? And 2, is it actually corporal physical punishment, which is not the case here. Here we have intentional caging of a child, which is not corporal punishment under the circumstances. Now, you also got an instruction about lesser included crimes. And so the law is that sometimes there are crimes and then there's a lesser included crime under it. And when evaluating a lesser included crime, you start at the top. And you make a determination first, did we prove the top crime? In that case, it would be aggravated child abuse. If you found that we have proven that crime beyond a reasonable doubt, you don't need to go and look at the lesser included offenses. The same is true for child neglect, and the lesser included crime is culpable negligence. I want to talk about kind of what the lesser is really quickly on each one. The lesser included crime is child neglect, is culpable negligence. For that, you just have to find that the defendant exposed RF to personal injury, and he did so through culpable negligence. The reason why this isn't really appropriate is it's subsumed in child neglect, and this doesn't take into consideration the fact that there's a parent-child relationship here, and that the person that the action is toward is a child. This could be any adult action towards another adult. Now, as for child abuse, which is the lesser of aggravated child abuse, there has to be an intentional infliction of mental injury, or that the person committed an intentional act that could reasonably be expected to result in mental injury. So again, when we're talking about intent, how does the state prove intent? You don't have to prove, or we don't have to prove, the thoughts in someone's head. That would be impossible. But we have to prove that there was an intentional act. So this defendant made actions with intention, meaning it's not an accident. He didn't accidentally build the room in his garage. He didn't accidentally lock his child in day after day. He didn't accidentally make it so he didn't have a bathroom. That's what the types of intent mean under the law. Don't make me do it.
Well, only when you move away from the mic.
The whole time.
That's why I said give her the mic.
So, and that is what the instruction of child abuse means. So, what you have heard from the judge and what is clear is what is not an element of a crime. What is not something that we have to prove in order for you to find the defendant guilty. We do not have to prove that every minute of the day the defendant abused his son. We do not have to prove that he was subjected to that abuse at every second of the day. It can be still child abuse when there are times where you are kind and treat your child appropriately, and then other times abuse the child, which is what is happening here. We do not have to prove to you that his confinement was 24/7. There's been a lot of discussion about, well, there were times where he was let out. Absolutely. The state agrees. Ronan agrees. His sister Fiona agrees. That has always been what they have said, what they have discussed about what happened to him. It's not every moment of the day. There are lots of times where they look like an ordinary family. It's what happens behind the closed doors, which is why we're here. We do not also have to prove that the victim was starving, that he was malnourished. That has never been our contention or the state's claim. We agree that he was not clinically malnourished. The issue with the food is that they systematically controlled and regulated him to an extent where it became abusive. There was social isolation. There was lack of access. There was lack of autonomy to a level in which it was objectively harmful to any person, but specifically to Ronan. That's why the food matters. Yes, he got dinner. He got breakfast most days. You can see on the video there's 1 or 2 days that as a punishment, he does not get dinner. But we sat here and watched him over and over and over again eating his meals alone in his room. It also is not a legal defense that a child has some type of diagnosis, a mental health issue, a substance abuse issue, a behavioral problem. You know, whether or not a child is born with a mental health issue or an intellectual disability or a behavioral problem, or an adopted child has those things because of trauma, because of genetics, because of a roll of the dice, that could happen in any case, adopted or biological. That is not a reason or a justification to abuse a child. And that's what the law is. And that's why you're not going to see that in an instruction that it matters at all. It is also not a legal defense that a child has behavioral problems. It's not a legal defense that it was hard, it was difficult, it wasn't as easy as the other children. It's not a legal defense that we tried other things. There's no justification legal for what happened here. It's also not a legal defense that we did not get good advice. Now, you're going to get the form in the form of the verdict. There's actually 3 counts, but I just showed 2 here. And I want to make clear that you make a determination, you just check one of these, but your determination on one charge can be different. So that means that you can find him guilty of one charge and not guilty for another. The evidence applies to all of the charges, but your determination doesn't have to matter. And some people get worried that it's going to be like on TV and the foreperson is going to have to read it out. That's not how it works in here. The clerk will read it. And this is the kind of the instruction that tells you that law that I just talked about, that a finding of guilty or not guilty as to one crime doesn't have to affect your verdict as to the other. Now, there is one instruction here that we haven't talked about a lot at all, and it's called the principal instruction. And you probably noticed that we have presented evidence of both actions and statements made by Timothy Ferriter, and also actions and statements that were done by Tracy Ferriter. And that's because although they're being tried separately, they're both charged. And so that means in cases like that, if the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person did. So they're co-defendants and can be jointly responsible for that action. So you don't have to, in your deliberations, make a separation between who did what. They are acting together in this criminal acts. Now let's talk specifically about the evidence that has been presented. First, you had the testimony of RF or Ronan. And he testified, and one of the first things that he told you and that I asked him about is how he felt about the treatment by his parents. And he told you that he found that treatment to be dehumanizing. He did not want to live in that structure in the garage, and that the defendant forced him against his will. I asked him, well, what would have happened if you refused to go in the room? And he told you that he would have been physically forced to enter that room. He would have been dragged against his will. He also told you that although he did not spend all time in that room, he did spend large portions of his day confined in that room. He told you that every single night he would be locked into the room without access to a bathroom, that there were large portions of the day where he would be locked in. Occasionally, a time or two, he would return from school, be put in, and be not let out until the next day. He would eat many of his meals alone in the room, and there was periods, more than once, where he was in the dark during the day. And, on cross-examination, Ronan also told you that, yes, it's true, he can remember the good times because their abuse of him wasn't absolute, but what their actions taught him. They taught him that his needs, personal, social, physical, did not matter. They taught him, they reinforced that he was bad and that the cruel and inhumane treatment is what he deserved. They taught him that it was his fault, that he deserved this treatment. And we can still see the impact of those lessons on Ronan today. It was apparent when he testified that those lessons, what the defendant's treatment did to him, are still there. And we see that those lessons haven't faded. And we could see that in some of the statements that he made. You could see that despite cruel, inhumane, systemically bad, harmful treatment, despite that, those people, the defendant, are still the only parents that he's ever known. That he still wants to please them.
Objection, facts not in evidence, and proper argument.
Overruled.
For a child, and you heard it from both Dr. Myers and Dr. Rappa, for a child, this type of behavior can be normalized. It's complex. It's confusing to have the people, the only people in the world that you are supposed to love and trust, to systemically treat you this way. And so for him, for Ronan today, as a 16-year-old, still a child, he needs to call it a mistake and say that they should be forgiven. But that's not what the law is. The law, when we look, Karen, sorry, did it again. When we look, we see that this was a systemic, harmful, cruel action by those people that he loved and he trusted. And under the law, it's something that's called child abuse. Now, in evaluating the testimony, we also have the testimony of Ronan's older sister, Fiona, who is now 17 years old. And so when this was happening, she was about 15, 16 years old for the time in Florida. And in that white box is one of the instructions you got, and it's about evaluating the credibility of witnesses. And in evaluating the credibility, one of the things that we look at is, does the witness's testimony agree with the other testimony and other evidence in the case?
Ms. Coakley, carry the mic.
I never wanted to be like a pop star, and that's how this makes me feel. Does the witness's testimony agree with the other testimony and evidence in the case? Fiona confirms. Yes, he was locked in the garage. She confirms the status of the room. She says that he had no other room in the house. She also says that the defendant is confined to that room for large portions of time in Florida, and that he is punished differently than his sister for the same action. She tells us that she was allowed to go to the bathroom. She had a room. She had access. And so did her sister Nola and even the baby Pierce. She tells us that at no point did she ever feel that there was any need for her to be protected from her brother, that she was never in fear for him, and that he never physically harmed her. There's one incident she can tell us about where he stole from her in Arizona. The defendant's actions towards the victim were normalized in the family. And I know that Fiona was really hard to hear because we did her through closed circuit. But as the judge told you, if it would help in your deliberations, you can re-listen to her testimony, and you can listen to the audio not from this courtroom, but from the courtroom we were actually in. But there, at the end, on that second day, we talked about, did it just, because this action, because this treatment was happening so often, did it become normal? And she said it was. And she said that at the time, I didn't have a name for what was happening to him, but I do now. And it was abuse. And then we have the testimony of Dr. Myers, who's an expert witness, a child psychiatrist who is still actively treating patients and a professor at Brown University. And he told us that based on his review, that the defendant's actions were malicious, cruel, and sadistic, that they constitute torture, that there was no legitimate justification for this ever, and the only reason that you do this is to harm someone. He told us that that treatment of Ronan resulted in psychological harm. He told us that it was emotional deprivation, psychological deprivation, and a physical deprivation. And that leads to a psychological impact. In those cases, it leads to a child that is withdrawn, isolated, depressed. It can lead to suicidal ideation. It can cause existing behaviors to deteriorate. So if you take a child that maybe has some pre-existing trauma, that has behavioral issues, it absolutely under no circumstances will correct or treat any of them. It will only make it worse. He told us that it will stunt psychological and intellectual growth of a child. He told us, and we just had a lot of discussions about reactive attachment disorder and whether or not that is appropriate here. He told us that there are indications that there may be an attachment issue, but that the defendant's actions would increase and exacerbate any attachment issues. That this is the worst thing that you can do for a child for attachment issues. He also talked about post-traumatic stress disorder and told us that the defendant's treatment alone is a traumatic event that can be a precursor to post-traumatic stress disorder. And that's what he thinks is happening in this case, because he agrees that there is PTSD apparent here in Ronan. He told us that even if they're not the original cause, they're not the chicken, they're not the egg, that it would make any symptoms worse. And there's been a lot of discussion about diagnoses and what it is and what caused it. I want to be clear. That does not matter what diagnosis there is or is appropriate or correct. It is not a legal defense. If a child has reactive attachment disorder, it doesn't mean you get to treat them however you want. What matters here is that there is an indication that the child may have been medically vulnerable because of past trauma. And instead of doing anything productive to assist that child, they did the worst possible thing you could do. Now, beyond the direct testimony, the photographs in this case, we have hours of ring camera because the defendant recorded every single moment in that room. And like we said, it's not a continuous stream, it's 1-minute videos related to action. But we have hours of the treatment, of the confinement to prove, to corroborate what Ronan said, that he was in there alone.
You want to take this thing to the next level? Let's do it. Let's do it in Florida too. Let's do it in Florida too. Let's go.
And so you don't have to take Ronan's word for it, that the treatment was extreme, that it was dehumanizing. We have the direct evidence of his actions. This is not a concerned father trying to make a reasonable correction to a behavioral issue. This is a man that is angry. This is a man that has actual malice, that has physical aggression and anger, because we see him put his hands on him, throw him on the bed, put his hands on his neck, scream on him, and then turn out the lights. And so his son is in an 8x8 box. The area that you're sitting in is bigger than that. Oh.
Sustain.
You can use your common sense for how big 8 feet is. Alone. And remember, we're looking through a camera that is has some night vision capabilities. Ronan told us what it's like to be in there, that when the lights are off, there is no ambient light. There is no window, that he's sitting in the pitch dark. So let's talk about the application of the evidence to the law. Aggravated child abuse. Malicious means wrongfully, intentionally, and without legal justification. What's in establishing or evaluating what is reasonable punishment? Is it corporal punishment? Things that are generally accepted as being a corporal punishment. A strike on the hand. Hitting a child on the back of their behind in a direct response as a punishment. Reasonable corporal punishment. Reasonable punishment does not subject a child to a risk of harm, and it does not cause actual harm, like the case here. It is not humiliating, dehumanizing, and cruel. It is proportional, and it is limited in duration. So let's talk about the duration here. Continuous. This is ongoing, and I think that's an important delineation here, right? This is not a proportional reaction to a behavior, like a discipline or a punishment. He has no other room in the house. There is no other place for him. Every other space is taken up. The parents have a room. Each of his daughters have a room. Pierce has the office. So there is no situation where he conforms his behavior to whatever standards the defendant wants, and then he is out of the structure in the garage. This is his life, continuous, even in the best case scenario. But we know that it was more insidious than that, because we look at the duration. January 6th, he goes in at 8:10 p.m. That's when they lock up the door for the final time. No more bathroom, no more glasses of water, certainly no snacks. The door's not open until 7:10 in the morning. He's in there for 11 hours overnight. January 8th, he goes in at 9:39 p.m. January 9th, the door is not open again until 8:35 in the morning, 11 hours. January 9th, 8:36 to 7:39. January 10th, 8:36 p.m. until 8:25 a.m., 12 hours. No bathroom, not a drink, not a chance of getting a snack. No way to escape if there is an emergency or a fire. Locked, deadbolted inside. When we look at January 13th, 4:49 p.m. to 6:18 in the morning, 13 hours on a regular basis. And the exhibit that the state showed you, all of the ring videos are in from that entire time period, but then we showed you hours of videos that showed every event. So him going in, and then when they come in again, he gets out. So those are the major blocks, the major events. When they come in, they go in, they out. And those are the numbers that we're talking about. When we look at the total in a day, okay, fine, not just overnight. How much of a 24-hour day is he in the room? On January 10th, he goes to the bathroom between 7:39 and 7:45 a.m., or 7:43, so that's when he's let out. He leaves the room at 9:05. He told us he got left around 9 to go to school. And then he returns to the room at 4:59, so after school. And then he leaves the room to go to the bathroom at 5:56 to 6:18 p.m., and then he's in for the rest of the night. So the total, if we go 12 a.m. to 12 p.m., is 14 hours and 22 minutes of a 24-hour day, and he went to school. Huge portions of this child's life are alone in this room. On January 13th, same thing. He goes out for 2 minutes to go to the bathroom at 7 o'clock in the morning, almost 8. He leaves the room to go to school at 9 o'clock. Back in the room at 4:49. He gets dinner at 7:02 and lights off at 7:26. He's in there for 16 hours if we're going from 12 a.m. to 12 p.m. And he went to school. January 20th, same thing. 6:43 to 6:45. Leaves the room at 9. Back in at 4:45. This time without the lights on. Dinner at 7 p.m. Now, was this every single day? No, because as we look at January 23rd, he gets unlocked, he gets released from the cell his father made for him at 9:07 a.m., and he's not back until 7:10 a.m. So yeah, he's out for most of the day this one day. That doesn't change this, though. The psychological impact. And when we look at the proportionality, it's important to remember that the time frame that we are talking about is the crimes that occurred in Florida. And so that is from December 2021 until January of 2022. You can see the things that he is getting in trouble for on that video. He's getting in trouble for stealing candy on that very first night. You stole chocolate from us, his mom says. Having an iPod in his room. Having a bad attitude. Lying. He tells a story about having a mock trial, and that wasn't true. Dr. Myers told us that kids subjected to this type of condition can have a fantasy life because they have nothing else going on, and so they have to have like a myth of themselves. Those are the things in Florida that he is being subjected to this type of treatment for. And I want to talk a little bit about intent, because there was a lot of discussion from the defense about intent. How do we determine someone's intent? For aggravated child abuse, it has to be that they maliciously punished, willfully tortured, or willfully caged. Those are intentional actions. We have to prove that the actions that they took were intentional, that he intentionally and purposely put him in that room, in that structure.
Objection, misstatement of the law.
Overruled.
That it wasn't an accident. That's the intention. That he willfully tortured, that he maliciously punished. Not every idea that was in his head. So how do we determine as a jury intent? We look to the evidence. You can make reasonable inferences from the evidence, and we look to his actions and then the things that he said in those circumstances. So let's look at the defendant's actions. That he did not give the victim a room in the house. He hired a contractor specifically to build this. He specified no windows, 8x8, lights controlled from the outside, lock, and a deadbolt from the outside. No bathroom, and he put that bucket in there. Each one of those steps are intentional, specific, deliberate acts. It's not an accident that this happened like this. We know exactly what he intended to do to his son. He set up the room. He put the camera in there. And then he forced the child to use a bucket. This is a screenshot from January 19th at 6:46 a.m. where he has to use the bucket. He had been in the room since 9:12 p.m. the night before. And this happened again and again. And in the morning, on one of the videos, you can hear the defendant tell him to take out the bucket and say, your neighbors don't need to see your piss bucket.
Mm.
From the outside, everything looked okay, but what was happening inside that room? Abuse. We see that the defendant's repeated actions to socially and physically isolate the child over and over and over again for hours last week. We watched Ronan alone in his room eating. And Dr. Myers told you about the impact of that type of social and physical isolation. His actions to take away every little step and bit of autonomy that he had no control over the temperature even in the room.
Okay. Did you turn the air on in your room?
Yes.
That was crazy, yeah.
You're supposed to touch that?
Did you hear Baba?
Yes.
Did you hear his question?
No.
Are you supposed to touch air conditioning?
No.
Why did you touch it?
It was getting hot.
I don't give a shit if it's getting hot.
Wow.
You're a tough guy. You don't touch the air conditioning. I'll deal with you tomorrow on that.
You know, in opening statement, defense counsel said that there was just a design flaw in the room. It's not a flaw. These are intentional choices. This is what he wanted to happen. This is what the environment that he intentionally subjected his son to. An environment that no reasonable person would think was appropriate or acceptable. And then after they have that conversation, both parents come in and ransack the room again and leave him with even less stuff sitting in the room. We have the defendant's actions, his choice that not only would he substantially socially and physically isolate his son, but that they had to subject him to hours of sitting in the dark.
So the attitude? Yeah. Oh, you're so tough. You're gonna say yeah? You're gonna hold it out? Yeah, bad attitude. Tough guy. Tough guy. What's this here?
What we have here is anger and derision. We have spite, and we want to cause him harm. That's why you're not trying to address behavior. What you're trying to do is maliciously punish him and make him sit in a dark cell for hours during the day.
Mm.
When we look at, one more. This one. This is a few minutes later.
So the attitude? Yeah. Oh, you're so tough. You're gonna say yeah? You're gonna hold it out? Yeah, bad attitude. Tough guy. Tough guy. What's this here? Bad attitude? Yeah. All right.
So when we're talking about like the reasonableness of the punishment, like look what he's doing that for there. He has a bad attitude. His 14-year-old son has a bad attitude, and that's why he gets to be locked in a room with no lights, which Dr. Myers told us is the same as solitary confinement, something that is universally condemned for most humans, but certainly for children, because of the psychological harm that that type of treatment caused. And we can see about how often that type of thing is happening. The camera is installed in the room on January 5th. That's the very first video we watched. And we went through each of these. We see that on January 9th at 8:36 p.m. They're mad at him, he's in the dark. no ambient light, a 4x4 room. On January 10th at 6:18 to 7:06, again, dark. On January 11th, 4:45 to 8 o'clock at night, and he doesn't get dinner that night because they're mad.
Ms. Coakley, pull the mic up because it's a recording issue for
Because
me.
they're mad. No dinner. On January 13th, again, 4:49 to 7:02, 2.5 hours in the dark in the middle of the day. And then they come in, and at 7:55 again for the rest of the night, pitch dark, no ambient light, not a window, 8x8. On January 14th, again, 4:49 to 7:02, he is sitting alone in the dark. Like Dr. Meyer said, systemic, ongoing psychological torture of a child. January 15th, 5:04 to 7:32, 2.5 hours more in the dark. On January 19th, 7:45 p.m., those lights get switched off again. On January 20th, 4:45 to 5:51. January 24th at 7:08 p.m., he's in the dark. And then January 28th is the last day. It's the day that he runs away. The defendant made deliberate, intentional actions. He put his child, a child that he knew was vulnerable because of his early childhood experiences, into this circumstance. Every single night, for periods of time during the day, he locked the door over and over and over again and didn't allow him to even control the temperature. His only option was to use the bathroom in a bucket, and he had no access to water on multiple occasions. And then, in evaluating his intent about what he is trying to do in this circumstances, we have what he says.
Tell me something? Stand up. Tell me something? What? Don't tell me what. This is your one chance. Don't look at me like an asshole. You want to tell me something or not? I have a nightmare. Yeah, from where? Blue van. Where? Green van. Excuse me? Green van.
Stealing again?
What the fuck is wrong with you?
You're stealing
fucking
like
disappointing.
chocolate, and you got so much stuff in your room.
Fucking great. You're just such a disappointment. You're gonna lose. I'm gonna take you out of that school, and you're gonna be in this room.
He's gonna be.
You're this close.
Where are these in here? Who are these?
Where are they?
These. This is like belongs to the cage or.
Let's get very good. See what your lion does? See what your lion does? You see it?
Is this?
We're going back to this?
Is this tape here?
So what we have is anger and derision. That's what's governing his decisions.
Yep.
And that's why we know that it's an intentional act.
Stand up. Why are you giving people shit attitude? Fuck that! Don't say I don't know. Why are you giving a shit attitude? I'm not thinking. Fuck that! Why are you giving a shit attitude? Answer me! Before I get really fucking pissed off, answer me. Why you giving her a shit attitude? We're in school today talking to your people to give you a better opportunity. You got a fucking shit attitude?
And after this, when he exits the room, he again turns off the light and leaves him locked in the room. And so how does that impact our ability to determine or make a conclusion about what his intent is? This isn't about getting a productive response or even having a proportional type of conversation. This exchange is about him having a bad attitude. And you can see even here where Ronan tries to say, I'm not thinking. That's why I'm having a bad attitude. And there is anger, aggression, the specter of physical force, as opposed to having any kind of conversation with the child. And then the response is to not have a conversation with them, not try to do anything that would be useful. Instead, locks him in the dark in an empty cell and turns the lights off. Because he's mad. He has malice towards the child. Now, I want to talk for a second about Arizona, because I know that maybe it can be a little bit confusing. We've had a lot of conversation about things that happened in Arizona and what happened in Florida. The defendant is charged with the conduct that occurred in Florida. And the judge has given you an instruction about how to weigh that conduct and how that can impact your deliberations. And that instruction is that the evidence of those other crimes, wrongs, or acts can be considered for the purpose of proving motive, opportunity, intent, preparation, plan, knowledge, identity, or the absence or mistake of accident. So that means that when considering the defendant's intent here, you can take into consideration his actions in Florida. You can take into consideration that this is not just something that he suddenly came to in Florida, that it just happened for 30 days. You can take into consideration that this is something that the defendant had been subjecting his son to for a period of 3 years. With, as Dr. Rapper told you, really no improvement, right? Like he was still having the issues that the defendant was concerned about, the bad attitude, stealing the sprinkles. And so, despite the fact that it was not helpful, that it was harmful, he continued to do it. It's an intentional act, that he continued to lock his structure, that it's his child in that structure, that there was a bucket, that there was no control over the lights or temperatures, that he used physical and social isolation. That this is not just something, oh, let me give it a try. This is something that he had been subjecting his child to for years. And you can take that into consideration when determining his intent here. That this was his plan, that he wanted to do this, that it was not a mistake. You can also take into consideration the physical abuse that happened in Arizona in evaluating the evidence in this case about what he was doing and what he was intending to do. Fiona told you that there were instances where she could hear the victim screaming while he's being struck in the garage in Arizona. She told you that there was one incident where he grabbed the child by the neck and lifted his feet off the ground, and Fiona was worried that he might accidentally kill her brother. And Ronan told you about those incidents too. And the reason, although he's not charged for those incidents here, the reason they matter here in your evaluation of the evidence is because that threat of violence, the fact that the defendant's anger and aggression and grabbing him by the neck like he does in the video, of shuffling his arm, of getting up in his face, is not posturing. That threat of violence is very real and significant for Ronan. And you can see that in the videos. You can see him cower. You can see him stand almost withdrawn. But it influences what the defendant is trying to impose on him with those threats, and also Ronan's understanding of what can happen if he disobeys. So let's talk for a second about the defense case. They put on some witnesses, and for the most part, the first day witnesses were the defendant's friends, with the exception of the teacher. Those friends do not know and never were in Florida.
Oh, no, nothing.
They do not know what was happening when the defendant was alone in a home with his son, and they do not know the type of punishment that he was subjected to. And absolutely none of them have any firsthand knowledge of what happened in Florida, because they never came in Florida, they never saw anything, and they do not know. The defense also put on a number of videos that we spent the better part of yesterday afternoon watching, which are times where Ronan was outside the house. And what we see from those videos that we saw yesterday is that for the vast majority of the time in the recording, that the victim is able to conduct himself in a family environment. He plays nicely with his little brother Pierce, who seems to very much love him and want to play with him and is following him around and trying to get him to interact. He is able to behave appropriately with his other siblings. You see him playing with the dog. We do not see violence or aggression You know, there's been kind of this idea floated that we had to keep the family safe. There is no evidence of that. The evidence is to the contrary. The person that was jeopardizing the safety of the Ferriter family was Tim Ferriter. We see that there are periods that he wasn't confined. And we agree with that. Ronan told you about that. When we look at the videos, we saw some videos of him on a scooter, which is on January 7th, 2022, after school. You can see in the videos that the state published that that's the outfit that he puts on. He leaves for school, comes back, he plays on the scooter. And then at 5:42 p.m., he's locked in the cell. And he eats dinner in there alone. And he's in there until he goes to sleep in the room where he cannot leave to get a glass of water or to get a bathroom. On January 9th, this is a Sunday, 8:45 a.m., the state's evidence is he's let out from the room. Then, like he told you, he was often, when he was outside of the room, having to do yard work. We see him in the defense exhibit moving those mulch. And you see in the defense exhibit, I took a close screenshot, but if you look over, the defendant and his wife are sitting at the table while the child's working. And then later that same day, there's those videos. Like he told you, one of the things that he had to do was to clean up all the rocks. And the state put into evidence video after video of him out there by himself, by hand, taking up the shelves. You see the defendant come take a look and come back and say every single rock. So yes, he did get out of the house, and sometimes he got to go on a scooter. Sometimes he had to do yard work, but at 6:25 every single night or earlier, he's locked in that room. The fact that on one day he watched a football game with his dad does not vitiate all the other days of systemic abuse.
Well, she used that systemic word too.
And then we have the testimony of Dr. Rappa. Dr. Rappa is their expert, a psychologist, and she told you that the way they chose to manage was probably the worst way that any person could manage these types of behaviors. She told you that the defendant's actions are the complete opposite of what anyone should have done with a child that has one of these conditions. She told you that there is a likelihood of psychological harm, even in children that had no underlying behavioral issues, that this is going to be harmful to anyone, but especially someone like Ronan. She talked about PTSD and reactive attachment disorder, and she told you that the defendant's actions would exacerbate the symptoms. That what he did made it worse. Actual harm. That is the defendant's own evidence. She says that this is not the recommendation that they received from any treatment provider. That she went through the records, and that what was recommended was medicine and therapy. And that there was very little of that done. And the last time that they dealt with any mental health professional for their son, who, according to the defense, they're so concerned about his behavior, was in 2019. The time frame that we are talking about is December of 2021 to January of 2022, 2 years later. No efforts. And we can see, and it's in evidence, you can take a look, when he is enrolled in school at the Palm Beach County School District at Independence Middle School in January of 2022, you fill out enrollment paperwork. And there, Tracy Ferriter says, normal dental, normal skin, normal eyes. Any concerns about general health? No. Any other specific illnesses or social or emotional or behavior problems? No. At no point did they try to get an IEP, an individual educational plan. At no point after 2019.
Objection, facts not in evidence as to the IEP.
Overruled.
We heard that, there was one email sent to someone about transcendental meditation, 2022. You know what else happened in 2019? Instead of doing anything productive to deal with the trauma maybe experienced by their sons or their behavioral issues, they locked him in the garage. Their biological son, Pierce, was born. They needed the bedroom. Ronan went into the garage. 2019 is when they stopped with the mental health professionals. In 2019, when that is happening. Those actions, what the defendant is taking, is not reasonable punishment meant to correct something. It is malice. It is willful torture. It is intentional caging of a child. Now, Dr. Rappo, there's a discussion about what started the PTSD. Was it the defendant's abusive actions, or was it just his childhood neglect? And you got an instruction about how you can evaluate a witness's testimony. That instruction is that you get to use your common sense in deciding what is the best evidence. You get to decide what should be relied upon in considering your verdict. You may find some of the evidence reliable and some not. So you can say that some of what Dr. Rappa said makes sense to me and I think is appropriate in light of the totality of the circumstances, and some of it doesn't really line up. But our experts agree, unequivocally, the defendant's actions were harmful. They should never have occurred, and they would have led to worse behavior for the victim. That there was absolutely no benefit to what they did. Instead, they were harmful. In a criminal case, the state's burden is proof beyond a reasonable doubt. And the law instructs us on what a reasonable doubt is. A reasonable doubt is not a mere possible doubt, a speculative or imaginary doubt. Such a doubt must not influence you to return a verdict of not guilty. And so what does that mean? If you're back there in the jury room and you find yourself speculating, well, this is what they could have meant. And it's not based on evidence, it's speculation. The law is that you have to stop. If you find yourself forcing a doubt or imagining a doubt, the law is you have to stop. A verdict of not guilty can only be based on a doubt that is reasonable. And when we look at the totality of the evidence in this case, there are no reasonable doubts left. Now, one of the instructions that Judge Coach just gave you is what the lawyers say is not evidence, and you should not consider it as such. The exhibits, the testimony, the video recordings, that is evidence. What I say and what the defense says is not evidence. You get to use your common sense. Every single day in courtrooms around the country, we convene ordinary people and we ask them to use their common sense about what is reasonable and about what is appropriate and what evidence is proof beyond a reasonable doubt. For about 6 weeks, Ronan Ferriter was locked in a room in Jupiter, Florida. And yeah, he got to go to school, and sometimes he got to go on a scooter, and sometimes he got to play with the dog. But as you heard from Dr. Meyer, that doesn't change the impact of this type of treatment has on any child, but absolutely on a child like Ronan. The defendant's intentional, repeated acts caused harm. Any person would know, any reasonable parent would know that this is not acceptable. Any reasonable parent or person would know that this is going to harm. And despite that, over and over and over again, Tim Ferriter made that intentional, deliberate decision to treat his son like this. That's actual malice. That's intentional torture. That is willful caging. It's aggravated child abuse. It's child neglect, and it's certainly false imprisonment. It's not just one thing or one moment. It is all the things over and over and over again. What the defendant did was a crime, and that's why we're here today. Like Ronan told you, it was dehumanizing, and it was traumatic, and it should never have been done. Based on all of the evidence, that is why we are asking you, all of that evidence, those hours of tedious videos, and I know it was tedious to watch them, but the reason that we did is to see just a moment of what that tedious was like for Ronan here. Based on all of the evidence and based on the laws of the state of Florida, we're asking you for the only verdict that is supported by the evidence and supported by the law. And that is a verdict of guilty. Thank you.
Fire. I didn't get to catch it all, but hey.
All right, we're going to take a short 10-minute break before we proceed with the defense closing.
Wow. So people were asking, so yeah, this is closing arguments. That was the prosecution. Then we're going to have the defense, and then they get prosecution gets a rebuttal. It's not looking good. It's not looking good. Because she even broke down. Then like at one point, she was like, they showed you this video, but what they didn't show you is they locked them right back inside. I'm like, what?
All right, everyone may be seated. Court will be in recess until 3:10.
And then they were talking about, yeah, they show you that one football game out of the years. You got to go watch a football game or in the, in the house. We hear the TV playing in the background. She's like, that ain't nothing. Oof. So who they need to not have what's the guy's name? Mahomed? No, it was Mahomed or something like that. They need to not have that guy. I don't know who's the plan. I don't know what the plan is. Not that it's gonna help much, but I think the female attorney on the defense is better than the male guy. He actually didn't do bad today, though. The guy, when he was arguing earlier, it seems like he got himself together. But it's gonna be tough. Wahid, hey, Wahid, that's his name. Yeah, that's gonna be rough. So I don't know. I've tried to give, try to be impartial throughout the trial to try to see both sides, but they have a hard time. They'll find him guilty on something. I mean, what are they going to do now during closing? They're going to play some more football games or something? Or and the other thing, too, because I was talking to a friend on the phone, they're asking me what else is happening today as far as this trial. I don't think that they're going to let the verdict deliberate today. I remember the other day they had said the defense asked that they prefer the jury to be fresh the next day. So I think once the closing is done, they'll probably let it go till tomorrow. What's tomorrow? Tomorrow's Thursday? Tomorrow's Thursday. Yeah. Kind of open and shut, I guess. Female defense attorney is Lutfi's favorite. Maybe. And hope you're doing good if you're out there watching. So I guess maybe we'll have to figure out what to do tomorrow. Or what? So it's going to be probably a verdict watch tomorrow. We'll have to figure out what we do, what we cover while we wait. I don't know if we do. I don't know. this stuff going on in Israel, but oh, oh, so interesting. So California enacted something called Ebony Alert law, which is the first of its kind in the nation to prioritize a search for black youth gone missing. So is that like gonna be like an Amber Alert? Ooh, oh, Elon Musk. Oh no, the drama on the internet. Elon, look what Elon said. What about Asian, Hispanic, white? I guess they're gonna have to make 4 or 5 different types of alerts. I thought that's what the Amber Alert was for. So we'll have new different alerts, I guess. Let's see. I don't know what I'm supposed to see here. What do you guys think? Tiny said, I hate Elon. So they got an Ebony Alert. Is that considered offensive to some people or no? I don't know. Maybe California should set up an alert system for missing black. Oh, Lord, let me not stop right there. Yo, Twitter. Jesus Christ. It's so stupid. Fuck. I mean, I can't with Twitter, man. But California still doesn't have an alert specifically for handicapped people. Ooh, that's what I'm saying. Everybody's gonna start coming out, so they want to alert for handicapped people. Handicap. Oh, what? Oh, he's joking. Native Americans identify as casual leprechauns. Yeah. I don't know. All right, I guess I got the Ebony Alert coming. I should probably like read it in my head before reading it out loud, right? I don't know. I'm just like in time, real time reading this shit. Well, let me see. What else? If they have, it's an article. Let's see what information now. They don't. Can you click it? All right, let's see. So it's a new law. Let's see how it's gonna work. Oh, they got NBC Black now. All right, cool. News Culture T. I guess it's like a new section of NBC. Okay. Gavin Newsom signed a Senate Bill 673 into law on Sunday, making California the first state to create an alert notification system similar to an Amber Alert to address the crisis of missing black children and young women. I mean, if they want to do that, I guess. So if it's a missing child or teen that's black, is it just gonna go to the Ebony Alert, or is it gonna go to the Amber and Ebony Alert? And I wonder how they're gonna navigate that. What is considered black, right? People have so many different things and feelings about, or what's black, what's white, what's whatever, right? Who falls into that criteria? There's gonna be a lot of people. I don't know. The law will go into effect January 1st, but allow the California Highway Patrol to activate the alert upon request from local law enforcement when a black youth goes missing in the area. The Ebony Alert will utilize electronic. Well, let me just make sure I don't have this muted. Okay, when they come back, we'll hear it. Maybe I'll just keep it like this. Okay, so the way it works is California Highway Patrol can activate the alert upon request from local law enforcement when a black youth goes missing. The Ebony Alert will utilize electronic highway signs and encourage use of radio, TV, social media. Democrat and creator of the legislation. He added, "We feel it's well beyond time that we dedicate something specifically to help bring these young women and girls back home because they're missed and loved just as much as their counterparts." About 141,000 Black children under the age of 18 went missing in 2022, and Black women over 21 accounted for nearly 16,500 missing person cases that year, according to the most recent data. More than 30,000 Black people in the U.S. remained missing at the end of 2022, although 38% of the people who went missing in 2022 were Black, according to the Black and Missing Foundation. Missing Black people are less likely than white people to have their stories highlighted in the media. Also, missing person cases for Black people remain open longer than those for white people. Derica Wilson, co-founder of the foundation, told CNN that a majority of the 6,000 cases of missing Black people in her database remain unsolved. In order for authorities in California to issue an Amber Alert, the victim must be under 17 or have a proven disability. There must be a reason to believe they're in danger, and the alerts cannot be used for custodial disputes, which happens all the time, or runaway cases. Part of the problem is that missing Black children are usually classified as runaways, and as a result, don't get an Amber Alert, according to the foundation. Since its inception in 1996, 1,127 children have been successfully recovered through the Amber Alert system, according to the U.S. Department of Justice. The Black and Missing Foundation has also found that Amber Alerts are inexplicably less effective when Black children are missing than for white children. Okay. Timothy Griffin, an associate professor of the criminal justice at the University of Nevada, Reno, said he believes that Amber Alert is not effective and therefore it may not be worth to replicate the service. So there's going to be kind of, I wonder if it is going to go out to cell phones and stuff like that. Wait, did they cut me down? Oh, the stream connected? Let me see if I can stop this. Disable that. Let me do this. Make a new stream. Give me a second. I don't know why it's doing that. Don't leave me, girl. No. Redirect.